In view of the foregoing discussions, analyzing the evidence on record meticulously, dispassionately, and objectively, we are of the humble view that when the original first information report seems to have been suppressed and the evidence of the solitary eyewitness PW8 cannot be said to be clear, cogent, trustworthy, and above board, and when a part of the prosecution case relating to the involvement of the co-accused Nirmala Barla in the assault of the deceased has been disbelieved by the London trial court, it would be risky to act upon the version of PW8 to convict the appellant. We are of the view that it cannot be said that the prosecution has successfully established its case beyond all reasonable doubt against the appellant. In the result, jail criminal appeal is allowed, the impugn judgment and order of conviction of the appellant and the sentence passed thereunder is hereby set aside. The appellant is acquitted of the charge under section 302 of the Indian Penal Code. The appellant, who is on bail by virtue of the order of this court, is discharged from the liability of his bail bond. The personal bonds and the surety bonds hereby stand cancelled.
May I please?
Pursuant to your lordship's direction, let the notary advocate is appeared in person. Also filed an affidavit.
Yes, Mrs. Patnaik,
Yes.
whether the order has been complied with, the investigating officer.
Give me 5 minutes, sir, because yesterday I had discussion with the SP and the IAC. They were supposed to send me the instruction. But this he is here. The notary is here.
No,
He-
we'll hear
Again,
together.
my
Yes.
lord,
Please.
just give me 5 minutes
Okay.
time. I'll just
Okay.
take it.
नहीं वीकली जो पासवर्ड से डाकतो
Quickly list password item number 8.
Nah, my lord, can I pray for tomorrow? File I
For
will
this.
take it. My lord,
Yesterday they have solved the copy.
no, I was under the impression, my lord, aji au kichhi asibani. So supplemental list dita matter asila.
ଏଇଟା କୁହାଇଥିଲା ୱିକଲି ଲିଷ୍ଟ ହିଁ ନିଆଯିବ
Dita just
ଠିକ
went
ଅଛି
out of the mind.
କାଲି ଏଇଟା ଡାକି
Kali.
Next सोमवार ଆସିଲେ
ହୁଁ
ମତେ କାଲି
କାଲି।
କପିଟା ଦେଇଛନ୍ତି 4ଟା ବେଳକୁ
Copy ରେ kichhi nahi, copy re to that is the repetition of whatever has been done. Kali aso, tadi kali fil ochhi be
सोमवार ଆସ सोमवार ମୁଁ କମ୍ପ୍ଲିଟ କରିବି
Monday, you have to alone argue. Nobody will be there.
third the land and council for the petitioner submits that he has received କଣ ଦେଇଥିଲେ ତାଙ୍କୁ
my lord jo ଆମର ଯାହା ଯାହା investigation ହେଇଥିଲା ଆଗରୁ ଯାହା ଦେଇଥିଲା ସେଟା ଗୋଟେ compilation
ରିପୋର୍ଟଟା ଦେଇଛନ୍ତି
report ଟା. So this is nothing new, something which is
what was
25/9/2023
what was solved yesterday
of course I remember my lord ଯଦି କରିଦେବେ ବି ଆଜି I don't
right the land and council for the state has filed the up-to-date status of investigation of CID crime branch PS case number 25 dated 39/2013 which is taken on record. Copy of the same has been served on the land council for the petitioner who seeks some time to go through the same and the matter may be taken up next week. List this matter on 3rd October 2023.
Can I
Yeah.
break one thing your lordship may kind of added? That is Rajgangpur PS case number 232 of 2012. Again, that has been converted to CID crime branch PS case number 25 of 2013. 12 ta point 13 inch. Initially, hochi Rajgangpur PS case number 232 of 2012. Because
ଲେଖା ହେଇଯିବ ଫାର୍ଷ୍ଟ ପାରାଗ୍ରାଫ ରେ
ha ସେଟା 13 kind
ଠିକ ଅଛି
oblige.
next
Item number 15.
why this matter was who told me? Minor daughter of the petitioner. Yes, what is your instruction in this matter, Mr. Tripathi?
Yes, we will. 15, 1-5.
Name of the accused persons have been indicated in the FIR, annexure 2, who is alleged to have kidnapped the victim, who is the minor daughter of the petitioner.
Let it pass over. Mr. Das will.
Once we go to the hearing matter, it would be difficult again to, that is why this is the last item for admission matter.
Let it come next week.
No, no, no. You just want to see that or register my friend from my daughter's son has been to the college, but she has not returned back to the house. I allow my family member on here and there, but I may found or their friend. Is the mother of the petition submitted representation of that before the chairperson staff from Collector IG Secretary Police from Yakuza se assume.
Item number 26.
Yes, Mr.
Yes, sir.
Where is Mr. Beura? In the last week, you told that
Yes,
let him be
he was
in
sitting yesterday also.
first item, the hearing matter, and you will not be there. देखिए ये पेपर बुक देखिए has been see Jumar Parida means son of Banshidhar Parida. Okay, I do not find any evidence against the
Jumar
accused.
Kodia
Has been
was
acquitted.
acquitted.
Okay.
Running page 18.
Okay, you come to the first information report.
Yes. Tullu Kumar Sethi.
Who is he? PW?
Tullu Kumar Sethi.
PW1?
Yes. Yes, madam. PW1.
Yeah.
ଝୁଲୁ କୁମାର ସେଠି ଟାଙ୍ଗୀ ଥାନା ଅଧୀନ ହାଟବରଡି ଗାଁର ଗ୍ରାମ ରକ୍ଷୀ ହିସାବରେ କାର୍ଯ୍ୟ କରୁଅଛି। ଆଜି 19/2/3 ତାରିଖ ସକାଳ 6:30 ସମୟରେ ମୁଁ ଗ୍ରାମବାସୀଙ୍କ ଠାରୁ ଶୁଣିବାକୁ ପାଇଲି ଯେ ଜୟନ୍ତପୁର ଗ୍ରାମ ନିକଟରେ ରାସ୍ତା କଡ଼ରେ ହାଟ ବିରିଡି କୁବେର ପରିଡାଙ୍କ କାଜୁ ବଗିଚାର ଗୋଟେ କାଜୁ ଗଛ ନିକଟରେ ଜଣେ ମହିଳାଙ୍କର ଶବ ପଡ଼ିଅଛି। ମୁଁ ତୁରନ୍ତ ଘଟଣାସ୍ଥଳକୁ ଯାଇ ଦେଖିଲି ମୃତ ମହିଳା ଜଣକ ବୟସ ପ୍ରାୟ 19 ରୁ 25 ବର୍ଷ ହେବ। ପ୍ରାୟ 5 ଫୁଟ ହେବ, ରଙ୍ଗ ଶ୍ୟାମଳ, ସାଧାରଣ ସ୍ୱାସ୍ଥ୍ୟ, ଗୋଲ ମୁହଁ ଏବଂ ଦେହର ଗୋଟିଏ ଗାଲ ସବୁଜ ରଙ୍ଗର ନାଇଟି ପିନ୍ଧିଛି। ମୃତ ମହିଳାଙ୍କ ଦେହର ବିଭିନ୍ନ ଅଂଶରେ ମାଡ଼ ଚିହ୍ନ ଏବଂ 2 ଗୋଡ଼ ନଳି ଗୋଡ଼ରେ କ୍ଷତ ଚିହ୍ନ ଅଛି। ମୁହଁ ଅଂଶରେ ନିଆଁ ଲଗାଯାଇ ପୋଡ଼ି ଦିଆଯାଇଅଛି ଏବଂ ମୁହଁରେ ପୋଡ଼ା ପାଉଁଶ ଢାଙ୍କି ହୋଇ ରହିଛି। ଘଟଣାରୁ ଜଣାପଡୁଛି ଯେ ମହିଳା ଜଣକୁ କେହି ଜଣେ ମାରି ସେଠାରେ ପକେଇ ଦେଇଛି ଏବଂ ଚିହ୍ନା ନ ପଡିବା ପାଇଁ ମୁହଁରେ ନିଆଁ ଲଗେଇ ଦେଇଛି।
Okay, so FIR was lodged against unknown person.
Yes, madam.
Name of the deceased is Tuni.
Yes.
So any eyewitnesses to the occurrence?
No.
No.
Circumstantial.
So let us see what are the circumstances which has been discussed by the learned trial court in the judgment. He has categorized what are the circumstances.
Yes, but there is
nothing like that. But it's a case where there is no direct evidence.
Yes,
But you come to paragraph number 6 of the trial court judgment. Let us see that. Page 7.
Yes, madam. The entire prosecution case rests upon circumstantial evidence. No direct evidence is forthcoming that the accused Devendra Singh committed murder of the deceased at his residential quarter at Ganganagar, Bhubaneswar, inside Division 2 office of PWD, and both the accused persons thereafter caused disappearance of evidence of murder by throwing the dead body of the deceased at the far off place of Jayantapur cashew nut orchard of Kubera Porida under Tangi PS. It was known to the people only on the morning of 19/2/3 who saw the dead body of the girl at about 20 to 22 years lying with her face upwards, which was burnt. The grammar of PW1 then reached the spot and informed the OIC. The dead body was wearing a green color nightgown. Marks of injuries of assault was found on the legs. The dead body was lying 5 to 6 feet away from the road. PW 2, 3, 4, 16 and 17 are the witness who only say about the dead body lying near the cashew nut orchard. PW 7 is the constable who accompanied the dead body for postmortem and returned back to the police station after the postmortem examination and handed over the green color nightgown, crystal necklace and the waist thread of the deceased before OIC. PW5 appears to be the co-villager of the accused, Devendra Singh. He said that about 4 p.m. he received a telephone call from the accused Devendra Singh who wanted to talk to his sister. He went and called his sister who talked to the accused over phone. The witness has been declared hostile, and he denies that the accused told his sister over phone that his niece, the daughter of the sister, had committed suicide by taking poison, and during the night, the accused brought the dead body of his niece in an ambassador card bearing number so and so. His sister is examined PW 21. She say that her daughter was staying with the accused in his government quarters since 4 months prior to her death. The wife of the accused had left him picking up some quarrel. The wife of the accused, Devendra Singh, has been examined at PW 15, and she admits that she was not residing with the accused because of the ill treatment towards her by the accused. But when she came to the accused hearing about some injury of his hand, she found a girl that stated to be the niece of the accused was in her quarter. Her father and brother, who were also there in the quarters of the accused for treatment, returned back, but her daughter was left there with the accused of his request. 3 days after she returned to the village, the accused telephoned her that her daughter was serious as she was assaulted by gundas. But when she told that there was no reason for the gundas to assault her daughter, the accused gave out that he had killed her. On the same night, the accused came to the village in a white car with the dead body of her daughter. She found marks of injury all over her body, which was lying on the back seat of the car. Seeing the dead body, PW 21 scolded the accused Devendra Singh, and so the accused gave out that he had committed a sin. When she refused to accept the dead body of her daughter, the accused went away in the car with the dead body. It appears from her evidence that the accused had telephoned PW 5, and when she got information about death of her daughter, she disclosed her in her house, and then the neighbor also knew it. When the accused came with the dead body, the neighbors were also standing in the veranda. She went inside the car, found daughter's dead body, and there was injury over her person. It appears from the evidence of PW 8, 9, 10 that on the same night the accused had approached them for crowbar, kerosene, and spade to bury the dead body of his niece. But when they scolded him and threatened him to call the people, the accused left the spot in the car. On the next day morning, the witness found the dead body of a girl is lying near Jayantapur Cashewnut Orchard, and then suspected that probably the accused had thrown the dead body during the night. I found the evidence of PW 8 to 10 do not suffer from any infirmity and improbability. There is nothing on record that these three witnesses are deposing falsehood. Thus, it is clear that the accused had been to the village of PW 21 with the dead body of his niece, the daughter of PW 21, but as she refused to accept dead body, the accused returned in the car and sought the help of PW 8 to 10 to bury the dead body. But having failed in his attempt to seek their assistance, he returned back during the night. Discovery of the dead body near about the early in the morning raises a strong presumption, and it appears highly probable that the said dead body might have been thrown there by the accused. The only question is if the dead body is that of the niece of the accused, and if he had killed the deceased.
So this paragraph which you read just now,
Yes, ma'am.
from this paragraph, it reveals that witnesses like PW 15, 21, then 8, 9, 10,
Yes.
they have stated something against the accused. Okay. All right. Yes,
Sorry, my lord. I will let.
continue. Paragraph number 7.
It is not disputed by the accused, rather admitted that he was the night watchman working in the PWD office at unit number 3 and was staying in the campus of Division 2 office at Ganganagar. It is also admitted by the accused, Devendra Singh, in his statement under Section under 13 CRPC that he was sent to subdivision office at Unit 3 since he neglected to perform his duties, but then was still residing at the outhouse inside the division office. The evidence of PW 11 to this effect has not been denied by the accused. It further appears from the evidence of PW 11, the junior engineer, that on 19/2/2003, the other watchman, Lingaraj, came and informed him that one driver was looking for the accused Devendra Singh to pay his dues with regards to taking the dead body of his relation to his village. He says that he did not see the accused Devendra Singh thereafter till he was arrested by Tangi police on 8/4/2003. It is his further evidence that on the same day, police seized some photographs, including some nude photograph of a girl from the outhouse where the accused Devendra Singh was residing. Out of the said photograph, one photograph was of the photograph of the accused and his wife, and the rest belongs to a girl. Another junior engineer, Dilip Kumar Patti, is examined as PW 18, who also corroborated the evidence of PW 11 regarding seizure of photograph MO4 series, including the nude photograph of the girl, which were kept in a small photo album and hidden behind the Lord Jagannath photo hanged on the wall. The accused Devendra Singh was also present at the time of seizure. PW 12, the watchman Lingaraj Jena identified the girl in the photograph to be the niece of the accused and says that after the wife had left the accused, picking up some quarrel, his niece came to reside there and she was with the accused for about a year. It further appears from the evidence of PW 12 that on the night of 17/2/2003, at about 12 to 1 o'clock, the niece of the accused, Devendra, came and knocked the door of the office and called him and requested him to stay in the night as her uncle, the accused, was assaulting her. PW 4 refused because he was alone in the office. It is his evidence that the girl repeatedly requested him to open the gate, but when he refused, she left, and on the next day, he saw accused Devendra Singh going out and coming into his quarter for about 30 to 40 times. And in the evening, at about 7:30 to 8 p.m., one white ambassador car came to his quarter. On the next morning, at 9 a.m., one man came and inquiring about the Devendra Singh disclosed that he had not received the higher charges of rupees 2,000 for taking the dead body of her niece. It is his further evidence that he had not see Devendra Singh from thereafter till he came with Tangi police. Such evidence of PW 12, I find, is consistent all throughout. It is also his evidence that when the driver came and inquired from him about the accused Devendra Singh, disclosing about non-receipt of the higher charges for taking the dead body of his niece, PW 12 informed this to his junior engineer. Thus, the evidence of PW 11 by Para 2 that he has informed by Lingaraj PW 12 that in the morning of 19/2/2003, a driver in search of accused for payment of higher charges of his car for taking the dead body of a relation of the accused Devendra Singh to his village is well corroborated. It is clear from the evidence of PW 12 that the dead body of the niece of the accused was taken in that car by the accused. The evidence of PW 12 that while the driver was in search of the accused Devendra Singh, another watchman Kishore Swain was also present. The watchman Kishore Swain is examined as PW 14. He also corroborated the evidence of PW 12 that a driver was inquiring about Devendra Singh and who disclosed that on the previous night he had taken the dead body of the niece of the accused in his car and Devendra Singh was to pay the higher charges. It is his further evidence that Devendra Singh had absconded and he saw him only with the police after 1.5 months. Thus, from the evidence of PW 11, 12, and 18, it is clear that some nude photos MO4 series of the deceased niece of the accused Devendra Singh was kept by him, and it is further clear from the evidence of PW 12 and 14 that the said niece of the accused died in the night of 18/2/2003, and her dead body was shifted in a car by the accused to his village. It also appears from the evidence of PW 12 that on the night before her death, the girl had approached him to stay in the night in the office since she was being assaulted by the accused. And from the morning thereafter, the girl was not seen. Such evidence does not suffer from any infirmities and improbabilities. Rather, the evidence of PW 11, 12, 14, and 18 are consistent and congent. There is nothing on record as why these witnesses would depose against the accused. It is also found from the Exhibit 10 and the entries by Exhibit 10/1 that the accused had remained absent from the office for which PW 19 by Exhibit 15 has informed to the assistant engineer that the accused has not been attending office since 12/2003. It is also clear from the evidence of PW 11 that 2 blue color pipes, 1 small iron rod, 1 thin can stick were seized from the said quarter of the accused of this on his production, and which the accused disclosed that with the pipe, stick, and iron rod he killed the deceased. MO5 and 8 are the plastic pipes, iron rod, and the can stick seized under Exhibit 7.
Disclosed means it was a extrajudicial confession of what? What is this? The accused disclosed that with the pipe and stick and iron rod, he killed the deceased.
This is doubtful because whether he was asked by the
we are here about just what it is asked to you whether it is under section 27 before the police such statement was made, or it was an extrajudicial confession.
The evidence of the PW 24 shows that he led the police team to the quarter and gave recovery of those.
Proceed.
The seizure of MO5 and 8 are also proved by PW 18. It is also the evidence of PW 24, the IO, that the accused gave information about the photographs and the weapon of offense used for killing the deceased. He opened the lock of his quarter, went inside, and brought the MO5 and 8. Thereafter, the IO himself recovered the photo album concealed behind a calendar pasted to the wall. The photo album contains 10 photographs, including 4 nude photographs of the niece of the accused and 1 joint photograph of the accused and his wife. 5 other photographs were also of his niece. Comparing the nightgown MO1, crystal necklace MO2, and the waist thread MO3 from the photographs, the IO was confirmed that the dead body which he found with face burnt lying at the cashew nut orchard of Kuberpoida was of the niece of the accused. The evidence of PW 21, PW 11, 12, 14, and 18, and PW 8 to 10, when read together, clearly proves that the niece of the accused died due to assault by the accused on the night of 18/12/2003, and the dead body was taken in a white ambassador car to the village of PW 21 by the accused. And when PW 21 refused to accept the dead body of her daughter, the accused returned back and approached PW 8 to 10 for their assistance to bury the dead body. But on the refusal, he threw the dead body near Cashew Nut Garden and fled away. Admittedly, from the evidence of PW 1, 2, 3, 4, 10, 16, 17, and 23, that the face of the dead body lying at the Cashew Nut orchard of Kuberpoda was burned. The postmortem report, Exhibit 11, also reveals that the upper portion of the body, above the collarbone, including the scalp hair, was charred. The Dr. PW20 also found several injuries like lacerated injury just below the right knee joint, bruise on the right side of the buttock, right thigh, left thigh, left calf, 3 bruises on the back of the midline, right side on lower portion of the back, right forearm, etc. The doctor says that such injuries probably was caused by a cylindrical object like stick, iron rod and pipe having half to 1 inches diameter. Her evidence is specific that there was fracture of hyoid bone which is antemortem in nature and the bond injury was postmortem in nature. According to her, the death was due to asphyxia by application of force on the neck. Thus, it is clear that the deceased has died due to the assault on several parts of her body and due to fracture of hyoid bone. The chain of evidence that the deceased niece staying with the accused was assaulted. Her dead body was shifted in a car to the village of the sister of the deceased of the accused, Devendra Singh, and her refusal to accept the dead body. It was brought near about the spot by the accused, who approached the 3 villagers PW 8 to 10 to assist him in disposing the dead body, and on the refusal he threw the dead body after body are established by the prosecution. The link is further established by PW 12, 14, 12, 11, 12, 14 and 18 and from the MO4 series that the deceased was no one than the niece of the accused who died was found by the PW1 and others. That the prosecution has successfully proved the accused Devendra Singh has killed the deceased and burned the face of the deceased in order that her identity might not be established. Excepting the PW 12 and 14, no other witnesses have stated that a driver was found coming in search of the accused Devendra Singh. And on their query, the driver has disclosed that Devendra Singh had taken the dead body of his niece in his car to his village, and he was to pay the higher charges of the car. Even the evidence of PW 12 does not disclose that the other accused, Jumar Parida, is the said driver. They also do not disclose that the IO PW 24 had come with the said driver, Jumar Parida, and the car was for identification, and they identified the accused Jumar Parida and the car. It is also not disclosed by PW 11 and 18 that the driver Jumar Parida and his car were brought to the campus of Division 2 office by PW 24. Accepting the evidence of the IO PW 24 that the accused Devendra Singh identified the driver Jumar Parida, and so also the driver Jumar Parida identified the accused Devendra Singh, no corroborating evidence is there. No other driver's statement within the campus of Capital Hospital have identified the accused Jumar Parida. The dhaba owner, where both the accused persons took meal after disposing the dead body, has also not been examined to prove that the accused Jumar Parida was with the accused Devendra Singh. The helper of the car, Kalia, has not been located by IO PW 24, who could have identified both the accused Jumar Parida and Devendra Singh. Neither PW 21 nor PW 8 to 10 have identified the driver of the car, nor have stated the registration number of the car. Thus, the identity of the driver being not established, I hold that the benefit of doubt must go in favor of the accused Jumar Parida. As I have stated, sexual perversity might be the cause of the murder, which I found from the evidence of PW 24 he says that when he contacted Biranchi Mishra, the owner of the photo studio, Ma Santoshi at Siripur, he disclosed that the accused Devendra Singh had himself come with the negative of MO4 series for developing and printing. The accused being the maternal uncle of the deceased, having taken the nude photo of his own niece, speaks about the sexual perversity. But the reason for committing murder is not disclosed nor established from the evidence. But when positive evidence against the accused is clear, cogent, and reliable, the question of motive is of no importance. In a Katana decision on the Honorable Apex Court have made it clear that the question of motive loses importance when the positive evidence of murder is clear, cogent, and reliable. The prosecution is not bound to prove the motive of any offense in a criminal case in as much as the motive, if any, is known only to the preparatory of the crime and may not be
perpetrator of the crime.
Of the crime and may not be known to the others. Therefore, sexual perversity might be the reason, but the motive is not known, and yet from the evidence, it is clear that the accused is the author of the crime. Hence, I hold the prosecution to has proved its case under section 302 and 201 of IPC against the accused Devendra Singh beyond all reasonable doubt, and accordingly I convict him thereunder. At the same time, I do not find any evidence against the accused Jumar Parda under section 201 of IPC, and thereby I acquit him under section 235(1) CRPC. He be set at liberty forthwith and be discharged from the bail bond. After this, appellant has been sentenced to undergo life imprisonment for section 302 and pay a fine of rupees 5,000.
Or you come to the accused statement, let us see that what are the circumstances against you, because it is a case where there are no eyewitness to the occurrence.
Yes, my lord.
So that it can be ascertained what are the, come to page number 30.
30, my lord. Question. It transpires from the evidence of PW1 that on 19/2/2003, while he was the grammar of Key attached to Tangi PS, hearing halla that the dead body of a girl was lying in the casino garden of Kuberpoda, rushed to the spot at 7:30 to 8 am and found a young girl of 20 to 23 years of 5 feet height wearing the nightgown was lying dead in the casino garden. What have you to say? Mu jani nahi, he replied.
Okay, this evidence obviously doesn't go against him. It's just that one dead body was found, and from the dead body also, what is that identity he has not perhaps stated.
Yes, sir.
So it's a general question. So he has stated the mujani nahi. Okay.
Okay.
The next one is,
It further transpired from his evidence that the face of the girl was burnt with some black mark found around her legs, and so he came away and reported the matter to the IIC over phone, and then went to the PS and reported the matter in writing by Exhibit 1. What have you to say? Mu jani nahi.
okay. Next.
Then third, it transpired from the evidence of PW4 that about a year back, hearing halla, he went to the Kazunat garden of Kuberpoda and saw the dead body of the girl wearing a green color nightgown was lying, and her face was looking black. What have you to say? Then mu jani nahi.
Next.
Question number 4. It transpired from the evidence of PW3 that about a year back, he found a dead body of a girl of 15 to 20 years of age was lying near Jayantapur Kazunat garden belonging to Kuber Parida, and the police made inquest over the dead body and prepared the inquest report, Exhibit 3. What have you to say? It further transpired from the evidence that the face of the dead body was looking black, like burning face. What have you to say? Janini. It transfer from the evidence of PW2 that sometime in February 2002, Tahsildar Banapur and additional Tahsildar Tangi called him to the cashew nut garden of Kuberapurda near Jayantapur, where a dead body was lying. What have you to say? ମୁଁ ଜାଣିନି. It transferred from the evidence of PW5 that about a year back at 4 p.m. he received a telephone call from you to call your sister. So he went and called your sister, who came and after 5 minutes received your call. What have you to say? ମିଛ କଥା. It transferred from the evidence of PW5 that about a year back at 4 p.m. he received a telephone call from you to call your sister.
Who is the sister of PW5?
PW21. Sister, PW21 is a sister of this appellant.
This is sorry.
Of the appellant. Devendra.
Okay, so the sister is PW21.
21.
Okay. Yeah.
And so he went and called your sister, who came and after 5 minutes received your call. What have you to say? ମିଛ କଥା.
Okay.
It transferred from the evidence of PW8 that during the night of 18 to 2003, while he was guarding poultry farm near his house, you came at about 11 to 12 o'clock in the night and asked his uncle's son, Basandar, for a spade. What have you to say? ମିଛ କଥା.
Okay, this is one circumstance that in the night of occurrence, you went to the house of the PW8's poultry farm, and there asked for a spade to the okay. That is okay. Next.
It further transpired from his evidence that when he asked you as to why you will require this spade at such hour of night, you told him that since your niece, aged about 10 to 12 years, had committed suicide, and as there is a party fraction in the village, your sister has called you from Bhubaneswar to cremate the dead body. What have you to say? ମିଛ କଥା.
Okay. This is one of those. Next.
It also transferred from his evidence that being afraid of your conduct, he and his brother asked you to go away as soon as possible, and thereafter you went away in the car, standing at a distance on the road. What have you to say? ମିଛ କଥା. It further transferred from his evidence that in the morning, while he was going to his land, hearing that the dead body of the girl was lying near Jayantapur cashew nut garden of Kuberopoida, he suspected that you might have thrown the dead body of the girl brought with you in the car. What have you to say? ମୁଁ ଜାଣିନି.
But from this question, it appears that PW8 perhaps has not seen that dead body. He has simply seen that car and the accused went away and
Yes,
he asked for a spade. But the dead body in the car he has not seen. PW8, as it appears. All right, we'll go through the evidence. Next is that, okay, come to question number 12.
It further transfers from his evidence that later he learned that the dead body of the girl was the daughter of your sister. What have you to say? ମୁଁ ଜାଣିନି. It transferred.
This is the daughter of PW21.
21. Yes. It is alleged, my lord. And I will come to whether the dead body is of the niece or not. It is doubtful.
Okay, Udar.
It is not proved, my lord. It transferred from the evidence of PW9 that about a year back at midnight, while he was sleeping inside his cashew nut garden, you called him, and when he opened the door, you asked for a spade and some kerosene. What have you to say? ମିଛ କଥା.
I would add ହେଲା spade and kerosene.
ଆଜ୍ଞା kerosene. PW99 କୁ ସେଠି କେବଳ spade ଥିଲା. It also transferred from his evidence that when he asked as to why you required these articles, you told him that you had come with the dead body in a white car and that this he shouted at you and threatened to call the people, and so you left the spot and went away. What have you to say?
Because what he says before PW8 allegedly stated that somebody has that niece who is aged about 10 to 12 years committed suicide, and there was gratification for which your sister has called you from Bhubaneswar to cremate the, that means the dead body perhaps is at Bhubaneswar. So he is to go and cremate the dead body. That is the information given
This
by
question number
PW8.
9 indicates that the dead body might be in the village. The sister called him from Bhubaneswar.
Right, that is how. But here it is stated as if you had come with a
Dead body.
he asked that as to why you are required the. He said that you had come with a dead body in a white car, and so you okay. Now come to the next question.
Question 15. It further transpired from his evidence that in the morning, people were seen running towards Jawantapur Kazunot garden belonging to Kuber Parida. As a dead body was lying there. What have you to say? ମୁଁ ଜାଣି ନାହିଁ ମୁଁ କହିପାରିବିନି ସରି କହିପାରିବିନି. It transpired from the evidence of PW10 that on 18 to 2003, while he along with his brother PW8 were sleeping inside their poultry farm, you came in a white ambassador car about 11 to 12 midnight, called them and asked for a spade. What have you to say? ମିଛ କଥା.
And this is PW
10.
10.
He's the brother, cousin brother of PW18.
Okay.
Both were sleeping together in the.
Mm-hmm.
It further transpired from his evidence that when he asked as to why you required it, you told him that your niece has committed suicide, and on being called by your sister, you had come to cremate the dead body. But since he became annoyed, you went away. What have you to say? ମିଛ କଥା. From this also it indicates that dead body was in the village. This appellant came on the, as his sister called him to cremate the body.
These three persons have actually not seen that dead body.
Dead body.
8, 9, and 10.
No.
Only his statement is that I have come for this purpose.
Yes.
Okay. Yes. Next.
It transferred from his evidence that when he asked you, question number 18. It also transferred from the evidence that in the morning, hearing the halla that the dead body of a girl was lying inside the Kazunot garden of Kuber Parida, he went and saw the dead body of a girl lying there wearing a green color nightgown, and her face was burnt by dry leaves. What have you to say? ମୁଁ ଜାଣି ନାହିଁ. It transpired from the evidence of PW17 that hearing about the dead body lying in the Kazunot garden of Kuber Parida, he went and found the face of the dead body was looking black. What have you to say? ମୁଁ ଜାଣି ନାହିଁ. Now PW17, he went to the field and saw the dead body. On the next day, it transferred from the evidence of PW15. PW15 is the wife of the this appellant madam. That you are her husband working as a night watchman in the office of PWD and staying in the quarter.
PW15 is the wife of the appellant.
Yes, madam.
Yes. Read it once again. The question.
It transfers from the evidence of PW15 that you are the husband working as a night watchman in the office of PWD and staying in the quarter at Ganganagar Chakka inside the campus of the office of PWD. What have you to say? ସତ କଥା. It further transpired from her evidence that since you ill-treated and assaulted her, she left you to reside in her parents' house since 1st February 2001. But 3 months after, she got information that you had some burnt injury because of hot radiator water of the car. And so she came to your quarter at Bhubaneswar and found a girl had given birth to a son. You told she was your niece.
You told
Who you told was your niece.
Acha.
What have you to say? Sabu ମିଛ କଥା. It also transpired from her evidence that she later learned that one of your cousin had taken the child, and on 4th April 2003 she learned from the police that your niece was murdered. What have you to say? ମୁଁ ଜାଣି ନାହିଁ. Here, evidence of the PW 15 that she came to know from the police on 4th April. But the dead body was found on 19/2. And on after 7th April, the IO came to know about that from some source that the dead body is the niece of the appellant. Thereafter, he started his investigation and examined this PW 15.
No. Date of occurrence is 18/2/2003 night. And date of detection of the dead body is 19/2/2003.
Yes, my lord.
Right?
Yes, my lord.
In the morning, it was detected. And the place where it was detected is the cashew nut garden of one Kuber
Parida.
Right?
Yes, my lord.
Okay. And the dead body was found having injuries and the face was burned. Okay.
Yes, my lord.
All right. So you proceed.
My lord, about this date of occurrence, whether the occurrence took place on 18 to...
We'll come to that. Just read
Sorry,
out here.
It transfers from the evidence of PW 23.
We'll have an overall idea after reading this accused statement, because all the incriminating materials against you must have been put to you for explanation. All right, put it. Next.
It transfers from the evidence of PW 23 that on 19/2/2003, while he was the Tahsildar Tangi, received the requisition from SDO Khorda to attend the inquest, and so he proceeded to village Tarapi, where in a cashew nut field, the OIC Tangi held inquest over the dead body of an unidentified girl as per Exhibit 3. What have you to say? ମୁଁ ଜାଣି ନାହିଁ. It also transfers from his evidence that the entire face of the girl was burnt. There were marks of injury of assault on her entire back, both legs, and abrasions on her hands. And she was wearing a green color nightgown. What have you to say? ମୁଁ କହିପାରିବି ନାହିଁ. It transfers from the evidence of PW 21 that you are her brother and the deceased Tuni was her daughter. What have you to say? हाँ सत.
So
this position is admitted.
Yes.
PW 21 that you are her brother and the deceased Tuni was her daughter. What have you go to the hospital? All right. Next.
It further transfers from her evidence that her daughter Tuni was staying with you in a government quarter inside the office 4 months prior to her death, and at that time your wife had left you picking up some quarrel. What have you to say? ମିଛ କଥା. It transfers from her evidence that your younger brother and father were also staying there with you for the treatment, and 2 to 3 months after they returned back to village, she had been to bring her daughter, but you requested her to leave her daughter for few days more, and so she allowed her daughter to stay back in your house and return to the village. What have you to say? ମିଛ କଥା. It further transfers from her evidence that 3 days after her return to the village, you telephoned her saying that her daughter was serious as she was assaulted by gundas. When she told you that there was no reason for the gundas to assault her daughter or to kill her, you told her that you had killed her.
Okay, so this is the extrajudicial confession
ma'am.
made before the sister, right?
Sister PW 21.
So extrajudicial
Confession before 21.
confession before PW 21 sister, no?
Yes, ma'am.
Mother of the deceased.
Mother of deceased. And from this statement also another thing reveals from the statement of PW 21
Yes, ma'am.
that the victim, that the deceased was staying with you.
Yes, ma'am.
Okay.
Yes.
Okay. In your quarter. Yes, next question.
29.
29.
Hmm.
It further transfers from her evidence that she asked you to bring her daughter immediately. And so, on the same night, at about 10 p.m., you came to the village in a white car with her daughter, who was then dead and lying on the backside seat of the car with mark of injuries all over her body. What have you to say?
Oh, so very important witness, PW 21. So noticed dead body in the car and with injuries also. It's injuries. Okay. All right. Next.
It also transfers from her evidence that seeing the dead body of her daughter, she scolded you, but you begged apology and told her that you had committed the sin and that you would also commit suicide by taking poison. And when she refused to accept the dead body, you left the village in that car with the dead body of her daughter.
This is the part of
Again,
Yes, ma'am.
confession.
Yes,
right. Next.
let me show that.
Yeah.
It transpires from the evidence of PW7 that on 22/2030, on the
Three.
instruction of
22/2003.
3, sorry,
Yeah.
3.
Hmm.
PW7 is the constable who accompanied the dead body for postmortem examination.
Hmm.
On the instruction of OIC, he took the dead body of a female aged about 20 to 21 years from the Kazunat garden near Joyantapur to Khurda hospital for postmortem examination. By dead body challenge exhibit 4, what have you to say?
Age is 20 to 21.
Yes, my lord.
Hmm.
It further transfers from his evidence that after the postmortem examination, the doctor handed over him a green color night gown, MO1, a crystal necklace, MO2, waist thread, MO3, which he produced before the OIC, along with his command certificate, which were seized under Exhibit 5. What have you to say? ମୁଁ ଜାଣିନାହିଁ.
Hmm.
It transfers from the evidence of PW 20. 20 is the doctor who did the postmortem examination.
Hmm.
That on 22/2003, while she was attached to DHH Khurda as assistant surgeon, conducted postmortem examination of an unidentified dead body of a female aged about 18 to 25 years
Hmm.
on police requisition
Hmm.
and found a lacerated injury of size 4 into 2 into 2 cm and the interior aspect of the right leg below the knee joint, a bruise of size 5 into 4 cm on the right side of the buttock, one parallel bruise of size 5 inches in length.
Parallel माने जो क्लव रे बाडी रे
आज्ञा
माड़ा हेले parallel bruise हो. Yes.
5 inch length, obliquely present on the lateral aspect of the right thigh.
Lateral.
Lateral. Another parallel bruise of size 4 cm in length present on the anterior aspect of the left thigh. Another parallel bruise of size 3 into 2 inch present over left calf. Bruise of 3 into 2 inches present over
pubic. Pubic.
over Monus pubis.
Okay. Left scapular injury अच्छी near midline of the right side, near the lower portion of the back. Abrasion अच्छी present on the right forearm, near the waist of the ventral aspect. What do you जानी नहीं? Yes. Then
it transferred from the evidence that she found portions of the dead body above the collarbone was charred, including scalp hair. Some portion of the left arm near the shoulder joint. What have you to say? ମୁଁ ଜାଣିନି. It further transfers from her evidence that on dissections she found hemorrhage inside neck muscles, fracture of head bone, neck. All the internal organs were congested.
तामाने ताकू माड़ हेची क्लव रे एवं तापरे तार गळा चिपा हेकिन ताकू फ्रैक्चर हेची हायर्ड बोन. That is the perhaps the cause of death. So he found the then taku poda is taro face ta. Yes.
He replied that mu jani.
Then next question.
It further transferred from her evidence that cause of death of the deceased was due to asphyxia by application of force on the neck since 24 to 72 hours from the time of her examination, as per report exhibit 11. What have you to say? mu jani nahi.
Asphyxia. Okay.
It transferred from the evidence of PW11 that you were engaged as a DLR since 1991, working as a watchman in the division office.
So homicidal death established by the evidence of PW 20. Okay. Doctor. All right. Next.
30 question number 37.
37.
It transferred from the evidence of PW11 that you were engaged as a DLR since 1991, working as a watchman in the division office, staying in the outhouse within the campus of division office. What you say? हाँ सत प्रथमରୁ नाइट वॉचमैन ର କାମ କରୁଅଛି. It further transfers from his evidence that you were sent to subdivision office at unit number 3 since you were neglecting to perform your duty, but then you were still staying in the outhouse inside the division office. What have you to say? हाँ सत କଥା. It further transfers from his evidence that 6 months prior to the occurrence, your wife had left you and your parents also left the quarter and went to their village. But your niece has come to reside with you 3 to 4 months prior to the occurrence and was staying with you even after your parents had left the outhouse. What have you to say? ମିଛ କଥା.
That means not only the evidence of that sister,
21.
but also 21, but
Yes, sir.
also from the evidence of this PW11,
Yes, sir.
also it appears that
She
the
was there.
She
was staying.
deceased was staying and wife had with some kind of dispute arose,
She has left.
she left. Okay. All right. So
It further transferred from the evidence that on 19/2/2003, the other watchman, Lingoraj, PW12, came and told him that one driver was looking for you to pay his dues relating to taking the dead body of a relation of your village, and later Tangi police came and arrested you. What have you to say? Michha kotha. It also transpires from the his evidence, that on the same day, police seized some nude photographs from your outhouse in his presence and in presence of PW18 belonging to the deceased girl, and some photographs MO4 series of you and your wife. What have you to say? ମୁଁ ଏବଂ ମୋ ସ୍ତ୍ରୀର ଫଟୋ ଥିଲା, ମୋ ଭାଣିଜୀର ଫଟୋ ନଥିଲା.
Okay. Yes.
It also transfers from his evidence that two blue color small pipes MO4 and 6, one cane stick MO7, one small iron rod MO7 were also seized from your house, handed over by you in their presence by the Exhibit 7. What have you to say? ମୁଁ
ମୁଁ କିଛି
କିଛି ଦେଇନି.
ଦେଇନି. ଆଚ୍ଛା, ମୁଁ କିଛି ଦେଇନି, ତାମାନେ ପୋଲିସ ଆଗରେ ମୁଁ ପ୍ରଡ୍ୟୁସ କିଛି କରିନି.
It's not recovered from him. That's what he
Okay.
Yes, ma'am.
Okay. Next.
It transferred from the evidence of PW12 that you were working in this division office as DLR and residing in the quarter inside the campus of division office with your wife, but after some quarrel, your wife had left you. What have you to say? ସେ ମିଛ ସତ କଥା, ସେ
ନାଇଁ ନାଇଁ, ସେ ଯିବା କଥା
ସେ
ସତ
ଯିବା
କଥା,
କଥା.
ମୋ ସହ କିନ୍ତୁ ଗଣ୍ଡଗୋଳ କରି ଯାଇନି. That is
ଯାଇନି.
what he said.
Yeah. It also transfers from his evidence that thereafter, for about a year, your niece, identified in MO4 series, were staying with you. What have you to say? ମିଛ କଥା.
Achha.
It also transfers from his evidence.
So that means, you see, just
He denied.
we just add it to that sister says, apart from sister, what are the other witnesses who are stating about the deceased staying in your quarter? So
Yes,
one
sir.
is that sister is PW
21.
21, the other is PW 11, PW 11, the other,
PW12.
and then PW 12. So these are the witnesses stated that deceased was staying with the appellant. Okay.
Yes.
Okay. Proceed.
Question number 44. It also transfers from his evidence that at about 12 to 1 o'clock in the night of 17/2/2003, your niece called him and told that you were assaulting her, and she repeatedly requested him to open the gate and allowed her to stay inside the office during the night. But since he was alone in the office, he refused, and so she left. What have you to say? ମିଛ କଥା.
So this is another circumstance. So this is the evidence of PW 12. Okay. By that time, the deceased had already been assaulted, and for which she came out and asking for a shelter in the office, which was not allowed. Okay, next.
It also transfers from his evidence that on the next morning, evening, at about 7:30 to 8 p.m., one white ambassador car came to his quarter, and on the next morning, at about 9 a.m., one man came and inquired about you. And when he asked about the reasons, that man told him that he had taken the dead body of your niece in a car and has not received the hire charges of rupees 2,000. What have you to say?
So yes.
This part of the story
Yes.
get corroboration from
Right.
this victim.
Yes.
Not only that, it corroborates the evidence of PW 21,
Yes.
his sister, because
Yes.
that the car with that dead body, you had gone
Was
to your
taken.
sister's, all right. Yes, next.
It transfers from the evidence of PW 14.
Hmm.
He is the watchman
Hmm.
in the PWD office.
Hmm.
And about 1 year back
Hmm.
at 9 a.m., one PW 14 is another watchman. About 1 year back at 9 a.m., one driver came to their office
Hmm.
and inquired about you. And on his query, he disclosed that on the previous night, he had taken the dead body of your niece in his
So-
car, and you were to pay higher charges of the car, but you were found absent.
So that part of evidence he corroborates.
14 and
12.
12.
Ah,
14.
ah. Okay, then.
It transfers from the evidence of PW 18
Hmm.
that on 8/3/2003, police seized 10. PW 18 is another JE of that division office.
Hmm.
Police has seized
It's
10.
either witness. He
Yes,
is
my
either
lord.
witness.
Yes, my lord. Police has seized 10 numbers of photographs, including some nude photographs of a girl kept behind Lord Jagannath photo hanged on the wall of the house where you were staying in your presence. MO4 series.
But see, this recovery is partly admitted by the appellant, saying that no wife's photograph was there.
Wife,
Was,
yes, my
so
lord.
recovery
Huh.
partly proved.
Recovery,
Accepted by you.
yes, my lord.
Only say that these girls' photographs.
photograph.
Yes.
Okay, then.
It also transfers from his evidence that
Hmm.
police seized an iron rod, PVC pipe, MO5 to 7 in your presence by Exhibit 7. What have you to say? ମୁଁ ଜାଣିନାହିଁ.
Same like the other witness.
Yes, ma'am.
Yes.
It transfers from the evidence of PW 19 that you were working as a DLR in his section office at unit number 3, Kharalanagar, Gangapur. What have you to say?
No answer.
Hmm.
No answer.
Next.
It also transfers from his evidence.
But this part 49 has already been admitted by him.
Yes, ma'am.
Ah.
So it is actually admitted.
Hmm.
It also transfers from his evidence that on 19/4/3,
3.
police seized the attendance register of his staff, wherein you were found absent from the duty from 12th February 2003 till 21/4/2003.
So
Exhibit.
this is the post occurrence contact of yours.
Yes.
You are
Yes,
absent
yes,
for 1.5
madam.
months.
Yes, my lord.
Post
Perhaps-
occurrence contact.
That exhibit is the attendance register, ma'am.
The occurrence actually took place on 18th of
18 to 2020.
23.
Right.
Yes, sorry, 2003.
truth. So 6 days prior to that, you were not attending the office until April. Okay. Okay.
Post occurrence
Huh.
contact.
Occurrence means that means from this they want that you were absconding.
Absconding.
actually. Yes.
It transfers from the evidence of PW 24 that on 19/2/2003 he was the OIC Tangi PS, and on that day received a written report of Tulu Kumar Sethi PW1 that a female unidentified dead body was lying near the Kazunut orchard of Kuberaparida with injuries of assault on different parts of the body and leg and face was burnt, on which he registered PS case number 22 of 2003 by Exhibit 1/2 and took up investigation. कही
Koi Next.
It further transfers from his evidence that he examined PW1, proceeded to the spot, found local persons at the spot, issued requisition to the SDM for deputation of executive magistrate to conduct inquest over the dead body, prepared spot map, Exhibit 12, sent requisition for deputation of scientific team to assist him in the investigation and collection of evidence. କହିପାରିବିନି. It also transfers from his evidence that he contacted the neighboring police station to ascertain the identity of the deceased, examined local villagers, visited the local village and railway station, back to the spot, and in presence of Tahsildar Tangi, executive magistrate, held inquest over the dead body and prepared the inquest report. Exhibit 3 took photographs of the dead body by MO9 series, seized the bond as sticking to the face of the dead body in presence of witnesses by Exhibit 2 by 1, examined other witnesses, and executive magistrate left the spot at 5:20 a.m. with the dead body, came to Kudi outpost, kept the dead body under guard, again visited the nearby village to ascertain the identity of the deceased, issued command certificate and dead body challan, requesting SDMO Khordar to conduct postmortem examination, and after a postmortem examination, seized MO1 to 3 series, the command certificate, the wearing apparels of the deceased, the red color waist thread of the deceased on production of constable number 570 by exhibit 5. What have you to say? It further transferred from his evidence that
No, that means by the time the postmortem was conducted, nobody was aware that whose dead body it was, right?
Yes, ma'am. Yes, ma'am.
Yes.
It further transfers from the
It
evidence.
further transfers from his evidence
Identity
that
of both the people.
since the identity of the deceased could not be ascertained, the dead body was buried by the constable near the Postono house. What have to say? କହିପାରିବି ନାହିଁ. It further transfers from his evidence that on 7/4/2003, he got information that the deceased happened to be your niece, and so he visited the village Tarapi, and the deceased was the daughter of Sushma Guru, PW 21 of village Santrapur, and was staying with you in your official quarter at Ganganagar in the campus of PWD office. What have you to say? କହିପାରିବି ନାହିଁ. It further transfers from his evidence that he examined your wife and came to know that you had driven her out. He also examined the watchman Lingaraj Jena, PW 12, and ascertained that
এটা কাহা এভিডেন্স এই যে কোশ্চেনটা
এটা PW 24.
No, 55 question or 55
PW 24 question.
24
IO.
IO আছে.
Yeah.
All right, then
It further transfers from his evidence that he examined your wife and came to know that you had driven her out. He also examined the watchman Lingaraj Jena, PW 12, and ascertained that the deceased was staying with you, and one day prior to your absence from the office quarter on 17/2/2003, you had assaulted your niece, and thereafter your niece was not found in your official quarter. ମିଛ କଥା. It further transfers from his evidence that you were found absent from office and quarter since 18/2/2003. What have you to say? ମିଛ କଥା. It further transfers from his evidence that during investigation, he ascertained that you were staying in the rented house of one Rabi Dhala at Polaspally and apprehended you at 3:40 a.m. on 8/4/2003.
okay, so date of arrest is
8/4.
8/4/2003
Yes, madam.
at 3:40.
3:40 he was apprehended, but the evidence of the IO shows that he was brought to the office, and around 9:45 he was arrested.
It's all right. He was apprehended at
Yes.
3:40. Then
Yes.
he was
Then
formally
Yes, ma'am.
formally shown to be arrested. Okay, yes.
It further transfers from his evidence that when he took you to the hospital campus for interrogation and further investigation, where the driver of the car bearing number DL 1C by F 3496, who was regularly in search of you for his higher charges, identified you, and you had hired his car to take the dead body of your niece, whom you had disclosed that your niece has died of fever. What have you to say?
This story of the car driver, first time the number came.
Yes, madam.
12 and 14 has already said that.
Yes. It further transfers from his evidence.
This driver was the co-accused, no?
Co-accused.
Right. He has
Who was
been
acquitted.
acquitted. Okay.
Acquitted.
Juma something.
Juman Parida.
Okay.
Juma Parida.
Okay. Yeah.
It
And
further.
he is the same guy who was asking for. He went and asked for 2,000 rupees.
Yes, my lord.
That
That is the allegation, but he could not be identified in the court.
The same guy.
Yes, ma'am. It further transpires from his evidence that the said driver accused Jumar Parida disclosed to him that you had taken the dead body towards Ranapur and from there to Tarapi, where you talked with two villagers and then came towards Kajunat Orchard, took out the dead body from the car and then burnt the face of the deceased and returned back. What have you to say? Micha kotha.
This is the IOS evidence. All right.
Yes, sir.
Next.
It also transfers from his evidence that he brought you and Jumar Parida to PWD campus, where the night watchman Lingara Jena, PW12, identified both of you and the driver and also the car. And so he seized the car under Exhibit 8/2 and arrested you and other driver. Micha kotha. It further transpires from his evidence that during course of investigation, you gave information about the weapon of offense used by you for committing the offense and led him to your villagers, where after opening led you to your quarter house of the villagers. Whereafter opening the lock, you went inside and brought out the can stick MO8, iron rod MO7, plastic pipes MO5 and 6, which he seized in presence of witnesses as per Exhibit 7. What have you to say, Micha kotha? It transpires from his evidence that he searched your house and recovered a photo album containing 10 photographs, containing one joint photograph, you and your wife, 5 photographs of the deceased, and 4 other nude photographs of the deceased, concealed behind the calendar pasted to the wall, MO4 series. What have you to say, Micha kotha? It further transpires from his evidence that the photographs, from the photographs, he could ascertain that the green color nightgown, black crystal necklace, and the red color waist thread found on the photo of your niece tallied with that of the deceased, which were also identified by the night watchman Lingorajana and the other accused driver Jumar Parida. And so he seized the photographs by Exhibit 6. Whatever you say, mu koi paribi nahi.
Then the dead body was identified through the apparels.
No, Malan. No. Only through the photographs of the dead body. Only through the photographs of the dead body.
And matched with the apparels she was wearing.
No. That was not proved.
Yes.
The apparels were not.
See, we'll see that because when the inquest was held,
Yes, ma'am.
This particular dresses were there. That
Yes,
is
yes,
green
madam.
color nightgown,
Yes,
black crystal necklace, and red color waist thread found. So
admitted.
these were also there in the photograph.
Admitted.
So that he tallied and said that is one of the reason
Yes,
why
ma'am.
he said
Yes,
that
yes.
it is of the deceased.
Yes, ma'am.
Same crystal necklace, same nightgown, and red color waist
Thread,
thread
right.
which was there. Waist thread, if it would have been not have been a nude photograph, it could not have been
Nude,
detected
Mhm.
because these were all nude photographs. These things were
Yes.
detected. Okay, black color crystal necklace and particularly this
Waist
red color waist thread. Okay, Yes, next.
65.
It is also transferred from his evidence that he came to Ma Santoshi photo studio accompanied by you and seized photographs which the owner of the photo studio, Biranchi Mishra, and admitted to have developed and printed to by him, and that he identified you. ମିଛ କଥା.
Biranchi Mishra PW?
No, Malady is not examined.
Not because in the photographs, perhaps the studio name is there or something. That is how he went there to that
No,
particular.
as per the version of the appellant, he went there. Because in the evidence of the PW 24,
I transfer that from his evidence that he came to Ma Santoshi photo studio କଥା କିଏ କହିଲା ତାକୁ ଯେ photograph ଗୁଡାକ ସେଠି ନିଆଯାଇଛି ବୋଲି maybe that in that photograph ରେ ଥାଇପାରେ
ଥାଏ ନା
ପଛଆଡେ ନାଇଁ ଥାଏ
ଥାଏ ତାର ଷ୍ଟୁଡିଓର ନାଁ.
ହଁ ତେଣୁ ଏଗୁଡାକ ଇଏ ଫଟୋଗ୍ରାଫ ନା ଡେଭଲପ ହେଇକିନି ତାକୁ ରଖା ହେଇଛି ତାପରେ ସିକ୍ରେଟଲି ରଖା ହେଇଛି କେତେ ଗୁଡାକ ଫଟୋଗ୍ରାଫ ବାହାରେ ରଖା ହେଇଛି ଆଉ କେତେ ଗୁଡାକ ଫଟୋଗ୍ରାଫ
From the photographs, I could ascertain that all the nude photographs, including the other photographs of the deceased, were taken inside the said quarter. I further ascertained that the accused Deva Singh himself had taken the photographs and given to Biranchi Mishra, owner of Ma Santoshi.
No, ତାମାନେ ସେ ଫଟୋଗ୍ରାଫର ଯୋଉ ପିକ୍ଚର ବ୍ୟାକଗ୍ରାଉଣ୍ଡ ଥିବ ସେଗୁଡାକ ତା କ୍ୱାର୍ଟର ରେ ଟାଲି କରୁଛି ଯୋଉଥିପାଇଁ ସେ କହିଲା ଯେ ଏଗୁଡାକ ବୋଧେ କ୍ୱାର୍ଟର ଭିତରେ ଫଟୋ ଗୁଡାକ ନିଆ ହେଲା ପରେ ଡେଭଲପ ହବା ପାଇଁ ଦିଆ ହେଇଛି କିନ୍ତୁ ଏଇଟା ସେ ଯୋଉ ଡେଭଲପ ହବା ପାଇଁ ସେଠି ଦିଆ ହେଇଛି ବୋଲି ଆଇଦର ମେ ବି ଟୁ ଥିଙ୍ଗସ୍ ଯଦି ଆକ୍ୟୁଜ ନିଜେ କହିଥିବ ତା ଷ୍ଟେଟମେଣ୍ଟରୁ ଜଣା ପଡୁଥିବ ନଚେତ ସେ ଫଟୋଗ୍ରାଫ ପଛରେ ଯଦି studio ନା ଥିବ ତାହେଲେ ସେଠୁ ହୁଏତ ଜାଣିଥିଆଇକି ଯାଇଥିବ ସେଠି but this man has not been examined as
no
so. Okay, now come to the next question.
It also 66 it also transfers from the evidence that on return to PS he examined Trinath Sundara, your cousin, who has been fostering the illegitimate child of the deceased. Examined other witnesses, PW 8 to 10, who also identified you and the car. Examined the parents of the deceased. Showed the photograph MO4 series, who identified the same to be that of the deceased. Issued request to Tahsildar Wanpur for preparation of spot map. Examined the junior engineer attached to the section office at Unit 3, Kharawala Nagar, and other junior engineers. Seized the attendance register from the junior engineer who confirmed your absence from the office from 13/2/2003 to 22/3/2003. Seized the office copy of letter number 74 dated 26/3/2003, by which he had reported about your absence to the assistant engineer. Request the executive engineer to preserve the spot house and then handed over the case in here to his successor, who only made a query as to if the injury could be possible by MO 5 to 8 and later submitted charge sheet. This query, neither the query report nor the
no ମିଛ କଥା ମତେ କେତୋଟି blank paper ରେ police ମୋର ଦସ୍ତଖତ ନେଇଥିଲେ. Okay, next question.
Trinath Sundar was examined.
Trinath Sundar, yes ma'am.
PW.
Trinath.
Brother of the.
Trinath. No, Trinath 6. He turned hostile.
Okay, we'll see that. Next.
It is also transferred from his evidence that he had examined PW5, who stated to him that you had telephoned him to call your sister, and when he inquired about the reason, you told him that his wife had engaged Gundas and killed Rajani, alias Kuni. That when he called your sister, you told her that Rajani has committed suicide by taking poison, and hearing this, he was taken aback. That at about 10 p.m., you brought the dead body of Rajani in a car bearing number so and so to the house of Hadimondu Guru, and after some talk, you went away with the dead body in
This
that car.
PW5 has supported the prosecution case.
Yes, my lord.
PW5 has supported the prosecution case.
He turned hostile.
Okay. अच्छा ये 161 पचार ଦେଇଛନ୍ତି ତାକୁ
ଆଜ୍ଞା
अच्छा hostile and PW6 also turned hostile.
yes, my lord.
Okay. All right, come to the next question.
It transfers from his evidence that he examined PW6, who has stated before him that during last April he had been to Bhubaneswar to purchase an auto and to went to your house, where he found the deceased had given birth to a illegitimate child, and so to save her being defamed, he took the child with him. What have you to say? ମିଛ କଥା.
This witness has supported.
No, my lord.
Hostile.
He told a different story.
All right. So what we have gone through that the one circumstance it is not disputed that the PW21 is the sister of the appellant.
Yes, sir.
That is not disputed,
Not disputed.
right? And the deceased is the daughter of PW21. This is also not disputed.
And that I dispute, my lord.
Okay, you dispute, but the evidence that the deceased daughter was staying
Yes,
with the appellant in the quarter, that has been deposed to at least by 3 witnesses, as we find.
yes.
One is PW21, that means the mother, and PW11 and PW12.
Well.
All these witnesses have supported the prosecution
Yes,
case. Okay. So let us go to the evidence first and see.
Yes, ma'am.
And another evidence, clinching evidence, on the occurrence night, the deceased had come and complained before one witness that
PW12.
PW12
Open the door, they didn't open the
open
door.
and because the accused was assaulting me, opened the door, he
take
did not
shelter.
open the door, and then he went away.
Yeah.
And he also stated that the deceased had come. Okay, so now the let us come to one by one. PW21.
My lord, before going to the evidence, I would like to put something, my lord. My lord, at the end of this, once the 313 accused statement, some important, this appellant has not given an opportunity to adduce his evidence, my lord.
Adduce his evidence means?
Adduce his evidence on his defense, my lord.
No. If you have said after this accused statement,
Yes, my lord.
if you say that no, I don't want to adduce
No, my lord, that question was not asked.
No, that was not
put,
but
my lord.
must
Yes, my
have been recorded here. Let us see that
Proceeding is recorded.
proceeding रे record ହେଇଥିବ ଆପଣଙ୍କର order sheet ଦେଖିଲେ
Proceeding is recorded.
ଆପଣଙ୍କର LCR ବାହାର କରନ୍ତୁ
ଆଉ ଗୋଟେ ଜିନିଷ ଦେଖିବେ ଇଏ ଯୋଉ 313 statement ରେ these the evidences which were put to these accused, whether it is 161 is put or real evidence is put to him.
Yes, my lord.
It looks like in many cases, many
Yes, my lord.
3 अच्छा ଆପଣଙ୍କ ଦେଖନ୍ତୁ accused statement ଟା record ହେଇଛି 3/11/2004 ଯାହା
ଆଜ୍ଞା।
appear କରୁଛି page 30
ଆଜ୍ଞା।
order sheet ଆମେ 3/11/2004 କୁ ପଳେଇବା
ଆଜ୍ଞା।
3/11/2004 हाँ that is এটা file order number হচ্ছে 33 order number 30 33 35 33 33 order you see accused Devendra Singh is produced in court. Accused so and so is present. Their statements are recorded. Call on so and so for defense and argument. Accused so and so to remanded till that day. Devendra, he present here. Jumar, he was on bail, so he was asked to remain present. Now, next day is 10/11/2004. Accused Devendra is produced in custody. Juman is also present. Defense declined to adduce the evidence. So, on 10/11/2004, defense declined to adduce evidence.
10/11/2004.
Yes, madam.
Right.
Yes.
So, your okay. So now you knew the position. Now you'll come to the one by one. Let us
21.
come to that 21.
My lord, first I want to bring to your lordship's notice the evidence of PW1, who is the grammar who first saw the dead body and informed the IO.
Okay.
Because,
Place it on your own way.
yes.
Okay.
That is on running page 48.
Right.
Okay.
And the grammar.
I am grammar attached to Tangi PS and working as such in village Hattavaradi. On 19/2/2003, I was working as such in village Hattavaradi. On the next day, on that day, at about 7:30 to 8 a.m., hearing halla in the village that a dead body of a girl was lying in the cashew nut garden of Kuberoparida, I rushed to the spot, found a young girl of 20 to 20 years, having height of about 5 feet, was lying dead in the cashew nut garden. She was wearing a nightgown. Her body was lying with her face upward, and a portion of her face was burnt. Some black mark was also found on her leg. Then I came away and reported to the IAC over phone. I then went to the PS and reported the matter in writing. This is my report, Exhibit 1. Exhibit 1 by 1 is my signature. I returned with the OIC to the spot who made inquiries. And cross-examination by the...
So this is in consonance with the FIR.
FIR.
Yes. What you want to point out from the cross-examination?
In the cross-examination, this PW1, he has stated, I had telephoned the IAC. I had never gone to the police station. Thereafter, the IAC came with other police officials to the spot.
No, this is just an information given.
Yes, my lord.
That a dead body was found there, and with some these are the things. So this is the way this
the
evidence.
written report was given 2 to 3 days after the dead body was found. His evidence in the cross-examination, the IIC stayed there for about 2 to 3 hours. The IIC did not ask me anything either at the spot or till today. After 2 hours, the IIC went away with the dead body. 2 to 3 days after this, I went to the PS. There I gave it in writing and signed a paper.
Because this
But it was registered on 19/2.
19/2, and it must have gone to the magistrate also, and magistrate signature. Record ta dekhi.
नहीं चीफ रे लास्ट 2 लाइन पढ़ो तू चीफ एग्जामिनेशन तो सी कोई चीज ना लास्ट 2 लाइन reported the IC over phone. Then I went to the PS and reported in writing.
Yes,
he went and writing. And this report is exhibits also. And I returned with OIC to the spot, made the inquiry.
You see,
telephone re कहला पुणी गला
FIR mark exhibit
1
এটা হচ্ছে FIR, এটা লজ হয়েছি সেটা কোনটা এটা ভুলে
এটা কোন
এটা ভুলে দিই FIR ପ୍ରଥମେ ରଖିବା କଥା କୁଆଡେ ତାକୁ ରଖିଛନ୍ତି ନେଇ FIR ତାପରେ ଚାର୍ଜସିଟ୍ ରହିବା କଥା ତାପରେ
statement କରିଦେବି ତାପରେ ଯାଇକି
ଚାର୍ଜସିଟ୍ ଅଛି
ଠିକ ଅଛି 20
ହଁ ରାଇଟ୍ ତ FIR ଟା
19/2
ହଁ
22 ରେ
ହଁ 22 ମାଜିଷ୍ଟ୍ରେଟ ପାଖରେ ପହଞ୍ଚିଛି ସିଗ୍ନେଚର ଅଛି ତ 4 ଦିନ ପରେ କୋଉଠୁ ଇଏ ହଉଛି ରିସିଭ୍ ବାଇ ମାଜିଷ୍ଟ୍ରେଟ 22/2020 okay yes argue your case so
Also, alert in the exemption chief, this PW1, the informant, he has stated that
he just found a dead body,
yes, ma'am.
gave the intimation, and that was reduced to writing, and the FIR also reached the court. So
Court.
on 19th, so there is no question of it is a belated lodging of the FIR or something like that. The FIR has already reached the court on 20th itself.
Yes.
Yes. So next is,
Then next, I am coming to the evidence of
and you will also
21.
find a number of documents where this PS case number must have been mentioned, like inquest report, then dead body challan, all those things must be dated 19. So there is no question of any subsequent FIR. Yes, next.
PW21,
Come to
running page 94. Sister of this appellant. The accused Devendra Singh is my brother. I do not know the other accused. Deceased Tuni is my daughter. My daughter Tuni was staying with the accused in his government quarter inside the office 4 months prior to his death. Wife of the accused Devendra Singh had left him picking up some quarrel. The younger brother with my father had also come to stay in his quarter for treatment, and my daughter had gone there.
That means Trinath.
No, my lord. No, he was not examined. Neither he was examined by the police.
Right.
ତା ଦେହ ଖରାପ ଥିଲା ବୋଧେ
ସେ ଦେହ ଖରାପ ଥିଲା ତାର
ସେଇଥିପାଇଁ
ସେ
ଆସିକି
ଟ୍ରିଟମେଣ୍ଟ ପାଇଁ
ରହିଛି
ଆସିଥିଲା
ସେଇଥିପାଇଁ ତାକୁ ରୋଷେଇ କରି ଦେବା ପାଇଁ ଇଏ
had
ଝିଅକୁ
gone there
ନେଇକି
to cook for them.
Yes.
2 to 3 months after the treatment, my father and my younger brother came back to the village, but my daughter was still in the house of my brother Deba Singh. 3 days after my father and brother came back to the village, I went to bring my daughter, but my brother Deba Singh asked me to leave my daughter for few days more, as she was preparing food for him. So I allowed my daughter to stay back and return to my village. 3 days after my return to the village, the accused Deba Singh telephoned me saying that my daughter was serious as she was assaulted by Gundas. When I told him that there was no reason for Gundas to assault my daughter to kill her, and the accused Deba Singh told me that he had killed her. I asked him to bring my daughter immediately. Deba Singh, on the same night at about 10 p.m., came to the village in a white car with my daughter, who was then dead. I saw mark of injuries all over our bodies. The dead body was kept lying on the back side of the seat of the car. Seeing the dead body of my daughter, I scolded him, but the accused begged apology and told that he had committed the sin and he would also commit suicide by taking poison. So I refused to accept the dead body of my daughter. Thereafter, Deba Singh went away in that car with the dead body of my daughter.
This word is also, it's just see, also means as if the She had also consumed poison. That's what
Yes, ma'am.
meaning.
Yes.
Yes.
Hmm.
That means the appellant will take poison.
That's
Yes.
what he
Yes.
To finish it.
Yes.
Cross-examination on behalf of the accused. I had left my daughter in the house of the accused as she was pregnant.
Hmm.
I stayed there for 17 days.
Hmm.
After my daughter delivered a child, I returned back to my village with my daughter,
Hmm.
leaving the newborn to one my relation. 6 months thereafter, my younger brother and father went to the house of the deceased to have medical treatment.
Hmm.
They stayed there for 4 months.
Hmm.
The accused came and took my daughter to his house
Hmm.
for prepare food for them.
Hmm.
My younger brother, Sibo, who had returned from Bombay,
Hmm.
was having 80,000 rupees as compensation from his company.
Hmm.
Since the deceased, they both took away that money. Both the brothers had quarreled.
Hmm.
They both told me that after 3 to 4 days, he would drop my daughter in the village
Hmm.
after purchasing dress materials for her.
Hmm.
They both telephoned to the house of Akhila Sundar Rai
Hmm.
and called me there.
Hmm.
When I got information about the death of my daughter,
Hmm.
I disclosed to in my house.
Hmm.
The neighbors also know it.
Hmm.
When the accused came with the car to my house, expecting me and my husband, accepting me,
Hmm.
me and my husband, no one went near the car.
Hmm.
Even none of the villagers.
Plant examine ही
No, man.
No, madam.
all right. Not examine. Okay. Hmm.
Even none of the villagers also came near the car.
Hmm.
My neighbors were in their veranda. I went near the car, but did not bring out
It
the
was a night
Night,
at
ma'am.
about 10 p.m.
10
right?
p.m.
Okay. Yes.
I went near the car, but did not bring out the dead body.
Hmm.
The area was then dark.
Hmm.
The accused Debo also did not come out from the car. My daughter was wearing a chudidar dress
Hmm.
and was covered with a shawl. At the time when the PW12 saw his dead body of her daughter, at that time the deceased was wearing a chudidar.
Hmm.
This is
But
the evidence
she
of
has identified her own daughter. What are you making? Yes. Yes. Inside the car,
I
she
went
has
inside the car.
identified her daughter. She was lying dead there. Yes. Dress, chudidar dress, so this, that,
Toss the
yes.
body.
Tossed the body of
Yes.
my daughter and found her dead.
Yeah.
My husband was near me by then. Touching the body of my daughter, I found injuries over her neck.
Hmm.
I also found blood over her neck. Debbo remained there for about half an hour. Both myself and my husband informed about this fact to the Gramaraki.
Hmm.
That Gramaraki was not examined.
Hmm.
Said Gramaraki told us that let him to take away the dead body.
Hmm.
It is not a fact that I did not disclose to the police that Debo Singh telephoned me saying that my daughter was serious as she was assaulted by Gundas. That when I told him that there is no reasons for Gundas to assault my daughter or to kill her, the accused Debo Singh told me that he had killed her.
Hmm.
It is not a fact that I am deposing falsely that accused Debo Singh brought my daughter dead in a car. It is not a fact that because the accused Debo had taken away all the compensation money of Sibo, I am deposing falsely against him.
How did you meet this evidence? You have nothing has been brought on in the cross examination. It's a very vital witness. This witness statement, if it is accepted, then many things comes against you. One is that the deceased was staying in your company on the date of occurrence. Number two, you have made extrajudicial confession before her. Number three, you brought the dead body in a car to the village of your sister. and she noticed the dead body lying in the backside of the car with injuries, and then you admitted the guilt and took away the deceased with her. So how can you get over this particular witness?
My lord, this PW 21 has been examined after 14 days.
Hmm.
After 48 days, my lord,
Hmm.
she gave her statement.
Hmm.
And in her evidence, she is stating that the appellant has admitted before me and gave an extrajudicial confession to have killed my daughter, and she remained for 48 days.
No, no.
Remained silent, my lord.
The who has stated that he was examined after 48 days?
This 21, my lord. After this dead body was found on 19/2/2003.
Dead body was found on
19/2/2003.
morning. It was detected in that cashew nut field,
Yes,
right?
my lord.
When the investigation also commenced from that day itself. So your argument that he made a belated disclosure,
yes, my lord,
before police,
yes,
about this extrajudicial confession, who have seen the deceased in the backside. So where you found that he has made a belated disclosure? From whose evidence?
My lord, on 7/4/2003.
No, no. Apono IU to anichan se kebe kain se evidence kain IU ro
24.
PW 24.
PW 24.
The deceased was married.
No, my lord.
That is illicit affair ru se pregnant ହେଇକିନି deliver କରିକିନି ସେଠି
That is
ସେଠିକି ନେଇଥିଲା, ତାପରେ ପୁଣି ନେଇ ଆସିଥିଲା ତାକୁ, ନେଇ ଆସିଲା ପରେ ଆର ଯେତେବେଳେ ଭାଇ ଆଉ ବାପା ଯାଇ ଦେହ ଖରାପ ଯୋଉ ଟ୍ରିଟମେଣ୍ଟ ହେଲେ, ସେତିକି ବେଳେ ତାକୁ ପୁଣି ସିଏ ନେଇକିନି ଗଲା, ନେଇଗଲା ପରେ ସେମାନଙ୍କର ଦେହ ଭଲ ହେଲା ପରେ ସେମାନେ ଫେରି ଆଇଲେ, ଇଏ ଆଉ ଛାଡିଲାନି ତାକୁ, କହିଲା ଇଏ ରୋଷେଇବାସ କରୁଛି ଥାଉ. Then this occurrence has taken place. So PW 24 is the IO.
Yes.
So
IO.
come to that very line.
Yes.
Where you said that he was examined at certain stage. PW 21.
103 page.
Page 103.
Till 27/3/2003. I was in search of clues to search the identity of the deceased, but could not. On 27/3/2003, I examined Kubera Porida, the owner of the cashew nut orchard. On 7/4/2003, I got an information that the deceased happens to be the niece of the accused Deva Singh of Tarai. Then after investigation,
investigation progressed, my lord. Then this PW 21, she gave her statement only when the police reached her place, my lord.
No. Where from you got the exact date? You said 4 months or 3 months. केबे आपण कहउछन एग्जाम
7/4 रे
कोड सेटा कोड पाइले
पेज 103 रो 1 2 3 4 5 6.
I got the information that this happens to be the 9. सेदिन ए जो आर स्टेटमेंट रेकॉर्ड हला ए जो साखीटा मो 21 नंबर
21 नंबर साखी सेटा आसीची
एटा देखंतु केबे रेकॉर्ड ହେଇଛି
18 नंबर लाइन बाय लॉर्ड 103 रो
103 रो
line 18. On 7/4/2003, I got an information that the deceased happens to be the niece of the accused, Deva Singh of Tarapi. So I visited village Tarapi and learned that accused Deva Singh was working as a DLR in PWD office at Ganganagar, Bhubaneswar. I also gathered information that accused Deva Singh had driven out his wife, daughter of Muli Pradhan of village Soran, and the deceased was the daughter of Sushma Guru of village Santrapur under Ranapur PS, and was staying with him in the official quarter at Ganganagar. I then visited Soran to the house of Muli Pradhan and examined the wife of accused Deva Singh and recorded her statement under section 161 CRPC.
Just a minute. ये हल्ला सुषमा सिंह
सुषमा
गुरु तार हजबैंड ना होची हाड़ी बंधु गुरु ये कौन मूली प्रधान किए
मूली प्रधान हो फादर इन लॉ ऑफ दिस अपैरेंट मैन.
हाँ and his wife of the accused Devasimu. Oh, ଆମେ ଚାହୁଁଛୁ ଏଇ ଯୋଉ ସାକ୍ଷୀଟା
ହଁ ସେଇଠିକି
21
ଆସୁଛି
ନମ୍ବର
ତାପରେ।
ସାକ୍ଷୀଟାକୁ ଆସନ୍ତୁ। 21 ନମ୍ବର ସାକ୍ଷୀ ଆପଣ କହିଲେ ଯେ he was she gave her statement at a belated stage, ସେଇଟା କୋଉଠୁ ଚିଫ ରେ ବାହାର କରିଛନ୍ତି
ହଁ
ନା
ଚିଫ
କ୍ରସ ରେ?
ଚିଫ ରେ ଅଛି।
କୋଉଠୁ?
ଚିଫ ରେ page 110 my lord.
I visited
100
110.
110
cross examination.
No, that is the examination in chief.
Cool.
110. After examining
I recorded the statement of Susma
Guru, Hadimondu Guru,
photograph
and Akhila Sundar Rai.
110 ହଁ
I recorded the statement.
এটা হচ্ছে সুষমা গুরু তো
PW4.
PW21 21
No, 24.
না হ্যাঁ PW24 রে যে সুষমা গুরু PW21.
Yes.
I recorded the statement of Swanso, then I showed the photograph.
Photograph of the deceased to Susma Guru, her husband Hadimondu Guru, and Akhila Sundar Rai.
Let us better হচ্ছে তার 161 টা দেখবে লিখিব এই এটা বাহার করলে তার এলসিআর টা বাহার করলে ট্রায়াল কোর্ট রেকর্ড এইটা নয় মো তার এটা ট্রায়াল কোর্ট রেকর্ডটা 161 ওটা আছে লাস্ট আড়ু থিব কোন তা না কোন
Susma Guru.
ସୁଷମା ଗୁରୁ yes ସୁଷମା ଗୁରୁ ଷ୍ଟେଟମେଣ୍ଟ ରେକର୍ଡ ହେଇଛି 9/4/2003 ରେ PW21 161 CRPC statement recorded on 9/4/2003. So,
After the identification of the dead body.
What is his February 19th February April?
Yeah. Till that day, his mother also she has alleged that his brother has confessed before him that killed her daughter. She had never come forward to before the police or reported before anybody. She remained silent. Only she gave her statement when the police reached her on 9/4/2003. And the evidence of PW24, sir, I showed the photograph of the deceased to Susma Guru, her husband Hadimondu Guru and Akhila Guru. All of them identified the photograph to that of the deceased.
No, have you put any question to this PW21 about before whom she had made a disclosure about the occurrence prior to giving the statement?
No, Malal, that was not asked.
21 was not asked.
And 21 also in her evidence, neither in chief or cross, she has told that the police has showed him the photograph of the dead body, from where she identified that the dead body is of her daughter.
Mr. Tripathi,
Yes, sir.
so why is that matter? The personal appearance of their advocate was there, and Mr. Patnaik was there. No, he there. I want to, about the Saswat Patnaik. Where is he? He was supposed to ensure the presence of that IAC.
But you have this PW21 is not second.
You see,
PW21 is very consistent.
suppose somebody you should bring out the material from a witness who is stated to be given a belated statement. Let us say that once he made a belated disclosure about the occurrence, that means there is chance of concoction
Yes, ma'am.
of a false story, okay, to implicate. But for that, you have to put some question to show that earlier the person is suspicious because the one side, the sister is giving evidence against the brother. You should not leave that part, that a sister is giving evidence against the brother, and the other side, her daughter is there. So maybe that she has he has kept it secret, that maybe out of fear, maybe whatever it may be. So unless you put some question,
Have you asked this to the IO?
No, my lord.
No,
No.
You not asked them.
so delayed examination जो जिनसटा आपण ता ऊपर जदी specific question
IO को
न
पचार-
पचारिबे ना accused को जे से particular witness को पचारिबे, हाँ से witness को at least आपनकर पचारिया थिला कि नाही जे आपण प्रथम थर पई केबे जानिले जे आपनकर डिसीज आपनकर झियो मरि जाइछि, ए कथा आपण केबे जानले ना घटना दिन। अच्छा तापरे आपन को पुलिस आसिकिनी केते मास पर पचाला, या भितरे आपण तो जानिले आपनकर स्वामी भी जानिथिले जे या हेला बिली ए घटना काहाकू कहिले, हाँ तेणु से खाली आपण पचारचंदी से जो चौकीदार बोधे ग्राम रखी who has not been examined.
Not been examined.
So ordinarily से questions गुड़ाक सबू पचारिवार थिला आपण बहुत जिंस, कारण एटा जदी अन्य कथा ही था maybe that my daughter is already dead, but if I give the evidence my brother would be hanged. That may be the thing for which she was keeping
remain silent.
So it cannot be, कारण relationship टाकू देखिया पड़िबो। जणे जेतेबेले मोर निज रिलेशन जेतेबेले गोटे क्राइम कर देइछि ऑलरेडी, जणे तो जी जीवा कथा जाई सैलानी मरि सैलानी, आउरी जदी मु एविडेंस देबी ताले तारो भी जीवो सिए, तेणु मे बी दैट वाज मे बी द कंसीडरेशन for which she was keeping mom. किंतु आपनको आनिबाकू पड़िबो ताकू जिंस किछि जे सीए जे तार किछि नॉलेज नथिला, एटा आउट एंड आउट गोटे फॉल्स स्टोरी क्रिएट कला आफ्टर दिस almost about 2 months धर देखा जाए, कारण 18 रे घटना हेछि, सी 18 राती रे जाइछि ताकू सेठी की कार नै किनी, तापर से स्टेटमेंट देइछि 9/4 रे पाखा पाखी 2 मास हे जाउ, तेणु 2 मास ये काहे की चुप रहिला। Have you put any question? The law is, if you find that unless you put direct question that why he kept mom for such an inordinate, why he did not normal course रे जा हबा कथा, जे जने माँ जानिछि तारो झियो को तारो भाई मर्डर करिछि, लेट अस से, एंड डेड बॉडी मध्ये नेइकिनी आस्तिला ती घर को, ता सत्वे मध्ये से कोन पाई 1.5 मास उपरे धरिकिनी काहा पाखरे कहूनी, सी केवल जानिनी ता स्वामी मध्ये जानिछि। अच्छा यार हुए तो अफेक्शन थाई पारे, किंतु तारो स्वामी हेले ब्रदर इन लॉ होछि ना, तेणु सी हुए तो भी का
अखिल सुंदर राय, he also not told that of PW5
when she saw the dead body, she scolded also. She scolded the
हाँ तेणु स्कोल्डेड माने आपणकर इमीडिएट रिएक्शन हवा कथा कोन जे पुलिस स्टेशन को जाई किनी लॉस करिवा कथा, that creates some doubt that but you should have put some question. Only the thing is that it may be, is it a state defense council?
Yes, my lord, state defense.
State defense. That is the problem.
And also, my lord, the evidence of PW24 in page 110, after all of them identified the photograph, page 110, my lord. All of them identified the photograph to that of the deceased. Sushma Guru,
गोटे नॉर्मल माटा जेतेबेले डेड बॉडी देखुची झियर कार भितरे तारो जो रिएक्शन हबा कथा से पाटी पाटी करिया कथा कंदा कंदी करिवा कथा अन्य मानकु डाकिवा कथा
ସେ reaction
माने
ନା।
सेई जो जिंस हबा कथा एई गुडा को आपण आनी थाते माने व्हाट आई वांट टू
Yes.
that is this should have been brought out in the cross examination to show that if you have not done all these things you have not seen that your daughter jone ordinarily tar reaction eya haba katha ତେଣୁ ଆପଣ ଏଇ ଜିନିଷ କରିନାହାନ୍ତି ମାନେ ସେଥିରୁ ଜଣା ପଡୁଛି ଯେ ପ୍ରକୃତରେ ସେ ଝିଅକୁ ନେଇକିନା ଆସିନଥିଲା ଏଇଟା ଗୋଟେ ମନଗଢା କାହାଣୀ କହୁଛନ୍ତି these are the art of cross examination which should have been brought on record to କେମିତି ଜଣେ ୱିଟନେସ୍ କୁ କେମିତି ତାକୁ ତାର ଏଭିଡେନ୍ସ କୁ କେମିତି ଆପଣ ଡିସବିଲିଭ କରେଇବେ ତ କ୍ରସ୍ ଏକ୍ସାମିନେସନ ରେ ଗୋଟେ ନର୍ମାଲ ସିଚୁଏସନ ରେ ଯାହା ଆଣିବା କଥା ଆସିବା କଥା ଏଇ ୱିଟନେସ୍ ର ସେଇଆ ରିଆକ୍ସନ ହେଇନି ତାପରେ ବି ମଧ୍ୟ ହେଇନି ସେ କାହାକୁ କହୁନି ପୋଲିସ ଷ୍ଟେସନ ରେ ଏତଲା ଦଉନି ତେଣୁ ଏଇଥିରୁ ଜଣା ପଡୁଛି ଯେ ଏଗୁଡାକ ସବୁ ଆପଣ ଥାକ ଥାକ ଦେଇକିନି ପଚାରିବାର ଥିଲା ମାନେ ଯୋଉଟା କି ପଚରା ହେଇନି
ସେଟା ତାକୁ ସେ ଯୋଉ ଷ୍ଟୋରିଟା ତ କନଫ୍ରଣ୍ଟ କରାଯାଇଛି to which he has denied. In para 4, it is not a fact that I did not disclose to the police that Debo Singh telephoned me saying that my daughter was serious and she was assaulted by gundas. That when I told him that there was no reason for gunda to assault my daughter or to kill her, the accused Debo Singh told me that he had killed her.
Confessed.
so
There, my lord, in the evidence of PW 24 in page number 10.
ଆପଣଙ୍କୁ ଯେତିକି circumstance ଆପଣଙ୍କ ଫେଭର ରେ ଗୋଟେ ଲାଇନ ଆସୁଛି ଯେ about the belated disclosure right before police but if you have not you see the ଆପଣ citation ମଧ୍ୟ ଦେଖନ୍ତୁ belated disclosure ଉପରେ ଯଦି ଖାଲି ଆପଣ ନେଇ question ନ ପଚାରିଛନ୍ତି ତାକୁ utilize କରିପାରିବେନି that witness must be given opportunity and from that the court has to derive yes belated disclosure जो witness टा कला एटा deliberately make out करिवार तार भितरे स्कोप अछि गोटे कहानी गढ़िवार आपण सब जिंस witness को opportunity देबेनी ताकू पचारिबेनी से विषय रे आपण खाली वर्तमान आमे देखिदेलु 161 टा रेकॉर्ड ହେଇची सी हमको डेट रे तेणु आमे एई डेट रे सी आसीथिला बेली कहूची 18 तारिख रे सी डिस्क्लोजर देला
No, Charlie.
किंतु कौन पाई सीए ये कलानी आपण सेई सब जो थाक थाक करी जदी जेरा रे पचारी थांते ना सीए जहा देई थांदा explanation whether that would have been acceptable or not that's a different it is it's a duty no doubt of the duty of the prosecution to explain as to why witness has been a statement of a witness he made a belated disclosure ତାଙ୍କର prosecution ର ମଧ୍ୟ duty ରହୁଛି କିନ୍ତୁ ଏଠି ସେମାନେ to some extent they have cleared it because the identity of the deceased was disclosed at a much later stage ତାପରେ ସେ ଜାଣିବା ପରେ ଯେ ଏଇ ଲୋକଟା
ଆର ଝିଅ
ୟାର ଝିଅ ବୋଲି ସେ ତାଙ୍କର ତାପରେ ସେ ଇଏ କଲେ ତେଣୁ you read the because ଏଇ type ର ଆପଣ ଏଠି ଦରକାର ଯେହେତୁ circumstantial evidence ଟା case ଟା ତେଣୁ ଆପଣଙ୍କର principle ହଉଛି the each circumstance has to be firmly established and that cannot be explained under any other hypothesis ଆଉ ଯେତିକ circumstance prove କରିବେ prosecution ତାକୁ ଆମେ ଗୋଟେ ଯଦି chain complete ହେଇଯାଏ ଯୋଉଥିରୁ କୌଣସି escape ହେଇପାରିବନି ଯେ it is the only deceased appellant who has committed the crime none else ତାହେଲେ ଆମେ ତାକୁ ସେଇ ଯୋଉ ପଞ୍ଚଶୀଳ ଯୋଉଟା କି ଶାରଦା case ଅଛି we can accept it but here when the evidence comes that the deceased was staying in your company her nude photographs were found in your room she was assaulted on that day just think over it she was assaulted on that day and she came and told before one witness maybe PW12 that I have been assaulted by the appellant and give me shelter he did not give the shelter. Okay. Then thereafter, what you are doing, the deceased was killed, and it's a homicidal death, right? Because the he was hired bone was fractured, number of injuries were there, and to support that it was assaulted by means of a club. तामाने बाड़ी रे माड़ होइची कारण से जो इंजुरी गुड़ा सब होइची parallel injury that is possible by club हैला तो सेही circumstance रे आपण भौणी को गोटे प्रथमे trying to give a false story ते ताऊ गुंडा माने मारे दे सीए सेठू पचाला जे गुंडा माने काहेकि मो झियो को मारी राइट तेणु सी को तापरे यू कन्फेस्ड इट ऑल राइट तापरे सी डेड बॉडी को नेकी ना आछंती भौणी घर को माने भाणीजी रो डेड बॉडी को विथ ऑल दिस इंजुरीज कार रो पछपटे सोईकिनी ताकू नेकी ना आछंती भौणी पाखरे डिस्क्लोज करचंती एडमिट करचंती एवं भौणी गाड़ी देइची डेड बॉडी को मध्य छुईकिनी देखिची डेड बॉडी बोली झियोर मध्य चिन्हिची आइडेंटिटी कैन नॉट बी डाउटेड because a mother is identifying her daughter lying in the back of the seat of that car. So even if it is a night time, but it cannot be disputed. ତେଣୁ ଟଚ୍ କରିଛି ମଧ୍ୟ ଦେଖିଛି ଝିଅର ମଧ୍ୟ ଇଞ୍ଜୁରି ଅଛି ବୋଲି ସେଇ circumstance ରେ ଗାଳି କରିଛି ଭାଇକୁ ଅର୍ଥାତ ଏ ଆପେଲାଣ୍ଟ କୁ ତାପରେ ଇଏ ଡେଡ ବଡି କୁ ନେଇକି ପଳେଇ ଆସିଛି ସୋ ଇଏ ଗୋଟେ circumstance ରହୁଛି ତାପରେ ଏଇ ପଏଣ୍ଟ କୁ ଅନ୍ୟମାନେ ମଧ୍ୟ ଯୋଉ corroborate କରୁଛନ୍ତି ଯେ deceased ଆପଣଙ୍କ ପାଖରେ ରହୁଥିଲା so last scene then coupled with the prior to the occurrence jaha jaha सब घटना गुड़ा गई assault part extrajudicial confession carrying the dead body then homicidal death
and post occurrence
absconding leading to discovery of those incriminating articles like the weapon of offenses so extrajudicial ei jo gudako jodi ame सबु gudako gote pore gote neikini jodi etiki jinso prosecution explain koruchi mane anikini apanko naare hoउची tahale can it be said that the chain is not complete can any other hypothesis be said that no maybe that some other person might have committed the crime এই possibility যদি আসিব যে some other person কারণ homicidal death যদি some other person might have committed the crime ର possibility ଆସୁଛି ତାହେଲେ matter is different ହେଲା କାରଣ last scene ରେ ବି last scene ଟା ଯଦି ଆପଣଙ୍କର बहुत केस रे अछि last scene खाली କହିଛନ୍ତି last scene is not sufficient itself गोटे जगह रे मन करो से माने देखा आइछि तार 2 दिन 3 दिन परे आउ गोटे जगह रे डेड बॉडी मिलुछि तेणु से माने कहउछन्ती जे ता भितरे अन्य केही मध्य डिसीज रो संस्पर्श रे आसीबार संभावना अछि तेणु सी मध्य क्राइम कर दबार डिसीज को मारिबार संभावना अछि सेठी से माने कहउछन्ती इफ द टाइम गैप इज लॉन्ग द प्लेस इज डिफरेंट देन लास्ट सीन एठी importance रखुनी एठी आपण पूरा right from the beginning not only she was staying with you she was assaulted you are carrying the dead body to the mother's house and there you are making the extrajudicial confession then you are nobody of course has seen you that burning her or cremating that body but thereafter you are absconding and then when you were arrested you are producing those weapons which were utilized and whether the we do not know whether the doctors have been doctors to query but
PW 24 ko regarding the delayed recording of 161 statement you are not seeing a single question just
yes that
and that is the once you do not put a question to the IO directly there is decision you will find that आपण कोन पई यारो बिलेटेडली ये कले ये प्रश्न यदि आपण पचारि थांते आईओ को से वे तो एक्सप्लेनेशन देई थांदा एक्सप्लेनेशन देई माने टू सम एक्सटेंट दे देई से कहि पार थांदा तेनु ताकू जे पर्यंत आपण से क्वेश्चन न ये करिसंती आईओ को आपण सेटा यूटिलाइज करि परिबेनी दैट इज द लॉ all right we'll take up this matter tomorrow we'll take up this matter tomorrow yes Mrs. Patnaik bring that file
But ଏଥିରେ problem କଣ ହେଇଛି ସବୁତକ address ଭୁଲ ଦେଇଛନ୍ତି almost. Like जो address टारे marriage certificate में
Please.
जो address ଅଛି.
Please wait.
Okay.
Let it file bar. Supplementary item number 2. You come to the fourth subparagraph of our order. Have you got the copy of the order?
No.
Order dated 14/9/2023.
Again. If
If the investigating officer is not a female, here whether he is a male officer or a female officer.
She's a lady.
Lady.
She's Swarnalata,
All right.
IAC.
So if that means she will go and the superintendent of Baleswar shall ensure a lady police officer. No, it is a he has to go to interrogate opposite party number 6 to ascertain opposite party number 6 who is
Urmila Rana.
who is the wife of this petitioner, right?
Address ta ଦେଇଛନ୍ତି Urmila Rana ର cause list ରେ, that is Berhampur. ସେଟା ଲେଖୁଛନ୍ତି Berhampur ଦେଇଛନ୍ତି ବୃନ୍ଦାବନ ନଗର.
Let us see that WPCRL.
WPCRL ର page 2 ଟା ଦେଖନ୍ତୁ.
Urmila Rana, कौन लिखा है जी?
आगो page 1 ରେ ଦେଖନ୍ତୁ my lord. जो 4 IAC industrial area industrial estate अंकुली एमती कहीं नाहंती.
कोड़ा
cause title ର 4th जो address टा दिया ହେଇଛି. जो IAC industrial area industrial estate अंकुली एमती कहीं IAC नाहंती. So that was ruled out. तापरे 5th रे IAC रूपसा PS station police station रूपसा टा district गंजाम लिखिचंती. सेठी गोटे confusion हैला. 6th रे उर्मिला नाना को जे ଦେଇଛନ୍ତି address टा वृंदावन नगर first line industrial estate अंकुली बरहमपुर. एटा बरहमपुर गंजाम रे आसुची. हमरो मैरिज सर्टिफिकेट रे अछि बालेश्वर एड्रेस. ये आईआईसी सिमुलिया जे स्वर्णलता से जाई कि खोजिचंदी सेठी से पाई नाहंदी काको. एबे हमें फोन करके एसपी का संगे कथा हला परे we think and suspect that even Mr. Das was also talking to them.
Because the basically this address is coming under the BNput Vaidyanatpur Thana Berhampur. So I immediately contacted the IAC to send someone to see that whether the person residing there they are not. They have said it may not. So it will take time. It may.
Okay, no. But the purpose is this:
yes, to know
that
whether
there has been any marriage or not.
Yes.
कारण जदि मैरिज ହେଇଛି कारण नोटारी पाखरे लेखा हला जो ये रे you come to the notary that marriage declaration.
जे बाहाकर ହେଇଛି ବୋଲି से लिखुछन.
हां
आज्ञा.
सेटा हम मध्य ऑर्डर रे रिफ्लेक्ट करिछु.
Yes,
right. So that is the order is very clear that she should be interrogated to ascertain whether first of which is whether she is wrongfully confined in the house of her parents or not.
Yes,
that is the number 2, or she is voluntarily staying there with her parents.
Right.
So this is purpose for this WPCRL. Next is whether any kind of marriage has taken place between her and the petitioner on 19/4/2023 in presence of their friends, relatives and well-wishers, jota ki mention is se jo declaration, and whether any documentary proof like photographs and video recording is available in support of the marriage. एटा होची ए जिंस गुड़ाक आसर्टेन करिकिनी रिपोर्टा दबाकू कुहाइतला. तेणु आपण वर्तमान पर्यंत आगे से तांको स्त्री को ए पर्यंत डिटेक्ट करि पारे.
आमे पचरु भी थिली मो पेटिशनर काउंसिल को से कोचंदी सेम ताकू गोटे जगह नहीं जाउछंती.
No, you lordship have a glance. There is a WhatsApp chatting, a lordship, the WhatsApp chatting that is documented also.
No, even Mr. Das called upon that number.
Let me allow.
ये जो WhatsApp number ता देखो
page 22, your lordship. There is a WhatsApp number, your lordship. The WhatsApp number has been given. That I provided to Mr. Das, and Mr. Das also contacted. And found that she is the mother of the victim.
Just a minute. Mr. Das,
after going to that particular number, the WhatsApp number, I called that person. Who is that person to know? But initially, I took the name of the girl Urmila. So immediately he told the wrong number. Then from my side, it is wrong.
नो नो
submitted.
आपण सेई जो नंबर टा
I got it.
कॉलर आईडी रे तो का ना थी
नहीं
ना
देखिला
अच्छा
देखिलानी. So I have sent it the number to the BN IAC BN court that it might be the number of the mother of the girl. So you contact him or call him and give me instruction. So let it take
I
time.
think in a day or two we'll find out.
Okay.
No, she
And that is the vital thing.
That's
Yes.
vital thing, yes.
If marriage, if there is a valid marriage,
My lord.
then
She's entitled to. She's
Okay,
entitled.
now you
Just now till
Even if there's a valid.
all right. We will go to that. Now who is the where is the notary? Please come here. What you have given?
one thing, madam, today's order, my lord, kindly be direction to the IAC BN court, my lord.
ଆପଣଙ୍କର ବାର କାଉନସିଲ ଲାଇସେନ୍ସ ନମ୍ବର କେତେ? କମ୍ ଟୁ ମାଇକ୍ ପାଖକୁ ଆସନ୍ତୁ. ଆପଣଙ୍କର ବାର କାଉନସିଲ ଲାଇସେନ୍ସ ନମ୍ବର କେତେ?
805 बाई
हाँ 800
5 बाई
yes
95
1995 କୋଉଠି ଆପଣ ପ୍ରାକ୍ଟିସ କରନ୍ତି?
सर बालेश्वर प्रैक्टिस करथिली
ବାଲେଶ୍ୱର କୋର୍ଟରେ.
वर्तमान सर नोटारी सिमुलिया ब्लॉक सिमुलिया तहसील अंडर
ନୋଟାରୀ ହିସାବରେ ଆପଣଙ୍କୁ କେବେଠୁ ସରକାର ଆପଣଙ୍କୁ ଇଏ
सर
କରିଛନ୍ତି?
12 मसर
ହଁ
12 मसर
2012 ମସିହାରେ. Have you got that documentary proof?
सर
2012 ମସିହାରେ ଆପଣଙ୍କୁ ନୋଟାରୀ ହିସାବରେ କେତେ ବର୍ଷ ପାଇଁ କରାହେଇଥିଲା?
सर 5 वर्ष
ଦେଖିଲେ ତାପରେ ଏକ୍ସଟେନସନ ହେଇଛି.
सर
ହଁ ଦେଖନ୍ତୁ ଡକୁମେଣ୍ଟ
ଆପଣ ଏଫିଡେଭିଟ୍ ରେ କିଛି ଲେଖିନାହାନ୍ତି?
ନାଇଁ ନାଇଁ ସେ ଦେଖନ୍ତୁ ଡକୁମେଣ୍ଟ ଇନିସିଆଲ ଇଏଟା ଦିଅନ୍ତୁ କେବେ ଏକ୍ସଟେନସନ ହେଇଛି ଦିଅନ୍ତୁ. This document was done which year? କେବେ ହେଇଛି ଏଟା 2023 ତ? Okay 2023.
19/4/2023
यार फाइल तो नहीं है ना आगे थोड़ा रही वाला यार बैग थोड़ा देखो बाहर में फाइल चाहे से पाखरे कि नहीं था तो बैग रही सर ना
ଆପଣ ଇଆଡେ ସିଆଡେ ଶୁଣନ୍ତୁନି. ଆପଣଙ୍କୁ ଷ୍ଟ୍ରେଟ ପ୍ରଶ୍ନ ପଚରା ହଉଛି.
सर
ଆପଣଙ୍କୁ କେବେ ନୋଟାରୀ ହିସାବରେ ଆପଏଣ୍ଟମେଣ୍ଟ କରାଗଲା?
सर
ଆପଣ ଯଦି କହୁଛନ୍ତି 5 ବର୍ଷ ପାଇଁ କରାହେଇଥିଲା 5 ବର୍ଷ ପରେ ଏକ୍ସଟେନସନ ହବାର କିଛି ଡକୁମେଣ୍ଟ ଅଛି କି ନାହିଁ? We want to know that as on the date when you this document was executed before you are a valid notary.
सर वैलिड नोटर सर
Have you got those documents with you now?
सर
Or you will produce it?
वर्तमान सर
ବର୍ତ୍ତମାନ ନାହିଁ ଆପଣ ପ୍ରଡ୍ୟୁସ କରିବେ ତ?
କରି ହବନି
କାହିଁ କରିପାରିବନି?
सर ତଳେ ରହି ଯାଇଛି ବ୍ୟାଗଟା କୋର୍ଟରେ
କୋଉଠି କୋଉଠି?
ଆଣି ପରେ ଦେଖି ନୁହେଁ.
ହଁ
ମୁଁ ଆପଣଙ୍କୁ ଏଇ ଯୋଉ କେସ୍ ଟା ଯେବେକୁ ରହିବ ଆପଣଙ୍କୁ ସେଇଦିନ ଆପଣଙ୍କୁ ଆସିବାକୁ ପଡିବ.
ଆଜ୍ଞା
You and you will also file your notary documents
Sir.
with an affidavit
Sir.
to show that as on that day you are validly discharging your duty as a notary public
Sir.
of Simulia.
Sir.
ठीक?
Sir.
Okay. Number
separate affidavit. What is it?
number 2 ଏଇ ଯୋଉ ଆପଣ କଣ ଲେଖିଲେ ଆଜି ଆଫିଡେଭିଟ ରେ ଏଇ ଯୋଉ ଦେଖିଲେ କଣ ଲେଖିଲେ?
ଫର୍ଦର ସାର୍ ସେମିତି ହବନି.
ହଁ
ମୁଁ କ୍ଷମା ମାଗୁଛି ସାର୍ ଫର୍ଦର ସେମିତି ଡକୁମେଣ୍ଟ ଏକ୍ଜିକ୍ୟୁଟ କରିବି ନା.
ଯୋଉ କାମ ଗୁଡାକ କରୁଛନ୍ତି ତାର କନସିକ୍ୱେନ୍ସ କଣ ହବ ଜାଣୁଛନ୍ତି?
ସାର୍
ସିଏ ଗୋଟେ ଝିଅ ସିଏ ଜାଣିନି ଯେ ଏଇ ଟାଇପ ର ଡକୁମେଣ୍ଟ ର ତାର ଲିଗାଲି କେତେ ଦୂର ଆକ୍ସେପ୍ଟେବୁଲ ହବ, ତାର ଲିଗାଲି ଭ୍ୟାଲ୍ୟୁ କଣ ହେଲା. ସେ ଝିଅ ମାନେ ବିଶ୍ୱାସ କରିଯିବ ଯେ ବୋଧେ ମୋର ମ୍ୟାରେଜ ହେଇଗଲା, ଏଇ ଡକୁମେଣ୍ଟ ବଳରେ ମୋର ଆ ସାଙ୍ଗରେ ମ୍ୟାରେଜ ହେଇଗଲା. ତାପରେ she will allow cohabitation with that man, then she will become pregnant, then that man will go away, cheat her, then she will be unable to prove her case that I am a legally married wife because she was believing तार सी जानी नहीं ना आपण जणे एडवोकेट नोटारी हिसाब रे आपण जानिछंती जे स्पेशल मैरिज एक्ट रे मैरिज केमती रजिस्ट्रेशन हुए मैरिज रजिस्ट्रेशन करिया पई को अथॉरिटी अछंती कहा पाखरे मैरिज रजिस्ट्रेशन हुए सेडा मध्य आपण जाननाती कोन मैरिज रजिस्ट्रेशन कहा पाखरे हुए केमती एप्लीकेशन दबाक पड़े केमती गोटे ऑब्जेक्शन पई समय रुहे तापरे कोन हुए सब जाननाती आपण जानी कि एगुडा केमती आपण कर दउचंती हां आपण देखिथिले जो सी आनिकिन लिखिदेले जे हमर बाहागर सब हेई जाईची मंदिर रे ये कोनसी डॉक्यूमेंट वेरीफाई करथिले जे बाबू तू देखैलो तम बाहागर त हेईची कोनसी मैरिज रो फोटोग्राफ देखैलो कि व्हाट्सएप रे ए जो मोबाइल रे रिकॉर्डिंग करछ आजिकल तो सब सब जिंस रिकॉर्डिंग होउची ना तो आपण किए से झिया आस्तिला ना नाही आपण को
सर
हां
सर
झिया आस्तिला
सर
पुआ आस्तिला
सर
किछि डॉक्यूमेंट देखिलेनी ये कर दी चली गला
एडवोकेट फ्रेंड भी थिले सर तांक सहित एडवोकेट फ्रेंड भी थिले
अरे बाबू
वे जो विटनेस गुडा एडवोकेट
ना सर आइडेंटिफाई
आपण सामना रे विटनेस साइन करछंती दी
सर
आपण सामना रे
सर आइडेंटिफाई भी सर एडवोकेट अंगर हला मु सर विश्वास रे उठे सर को कर दिले आ भूल कर
काली मन करंतु काली से झियो आसी कहइबो मु उदाहरण दउची से झियो कहइबो आज्ञा मोर से पुओ संगे बाहागर हेनी मु एग्जांपल देई कहूची तापर आपणकर कोन हबो सी तो फॉल्स डॉक्यूमेंट दउचंदी बेली सी अलगा कथा तापर आपणकर कोन हबो जदि गोटे फोर्ज्ड डॉक्यूमेंट को आपण जदि क्रिएट करिवारे आपण पार्टिसिपेट करूचंदी forced document to show that there has been a legal marriage between X and Y. ताकू आपण प्रोत्साहित करूनाती आर यू नॉट abating the commission of that crime गोटे forced document create करेबारे आपणकर रोल रहउची ना नाही if the girl comes and say that my signature was obtained fraudulently this in plain paper and I have not married I do not know the contents ताले कोन हबो आपणकर टिके चिंता करी कहंतु हला एमती एफिडेविट एमती दे दिल हबोनी वी आर नॉट सैटिस्फाइड विथ योर ड्यू टू इग्नोरेंस अबाउट आपण जणे एडवोकेट जे कि जार लाइसेंस होउची 1995 मसियारू 2023 मसियारे आपण ये करिवे आफ्टर 30 years almost 28 years of practice if you will say that you are ignorant then what can be done
ignorance is no defense
ignorance of law is an excuse आपण कहबे मनीष मारी कहबे मु आज्ञा जानिनी मनीष मारिबारे आजीवन कारादंड आ फांसी अछि तेणु मते क्षमा कर दियंतु इज इट यू आर एन एडवोकेट you are supposed to know the niceties of law but how can you make such a all right we are giving you an opportunity mr you produce that lekhandu the learned counsel for the I am writing both of your names yes. Miss Mrs. Saswat Patnaik and Mr. Both of them submit, additional government advocates submit that they may be given some time to comply the order dated 14/9/2023 and the investigating officer shall record the statement of opposite party number 6 and collect the information
टिके मतलब सेठी आईआईसी
अच्छा
बीएनपुर है
the IIC की
आईआईसी बैद्यनाथपुर थाना बरमपुर
IIC बैद्यनाथपुर police station है ना
through an lady officer
who is also a lady officer
he is not a lady officer he will send a lady officer
अच्छा IIC बैद्यनाथपुर police station will depute a responsible lady police officer है ना for recording the statement of opposite party number 6 which will be produced along with the other queries made in that order है ना on the next date এটা ଗୋଟେ paragraph ଲଗି ଦିଅନ୍ତୁ the Mr. Ashwini Kumar Mahanti the Notary Public Simulia Baleswar is present as per the order dated 4/9, and Mr. Chittaranjan Swine and his associate filed power for the Mr. Mahanti, which is taken on record. After going through the affidavit filed by the Mahanti, we find that he has mentioned that due to ignorance about the case laws and the judgment of the Honorable Supreme Court and this court, he had executed the declaration of marriage documents in favor of the executants. When we made a query to the advocate concerned about the enrollment number, he said that it is 0805 1995, and he was practicing in Baleswar court, and thereafter he was appointed as notary public in the year 2012 for 5 years, and the tenure was extended. Let the notary public file a further affidavit annexing the relevant documents regarding his appointment and his extension, and also the enrollment certificate, and the file another affidavit explaining under what circumstances he executed the marriage declaration. What is that? Marriage declaration? Marriage declaration certificate issued in favor of the petitioner and the opposite party number 6, and what documents she has verified to come to the conclusion that the marriage between them had already taken place on 19/4/2023 in the presence of their friends, relatives, and well-wishers, which has been mentioned in the marriage certificate. List this matter. Kebe rakhiwa kuhuntu? List this matter on 5th of October 2023. A free copy of the order be handed over to the Learned Counsel for the state as well as to the notary public. He shall appear before this court on 5th October 2023. All right. Yeah.
May we permit to correct the hospital so far the district Ganjam Institute district Balasore.
Which one?
Hospital like and mention
That number Panchanav data correct.
Acha, the IIC
Rusa police station district is Balasore lords.
Okay, seita correction karibe, district ta collection karibe. How konta correction karibe?
Pura correction karibe.
Charta pura Boidhanathpur police station.
Eta acha. All right. The Learned Counsel for the petitioner seeks permission to correct the address of opposite party number 4 and 5. Learned Counsel for the state has no objection. Permission is granted. You file a phrase cause title.
Obligations.
The Learned Counsel for the petitioner shall file a phrase cause title, giving copy to the Learned Counsel for the state. All right. We'll take up this matter on 5th October 2020. That's it.
His unmarried daughter is there. Because of the pendency of this case, his service benefit could not be released. May I pray about 10 to
10 times we have mentioned it, but it has not been listed.
No, the daughter has been permitted to continue the appeal.
Yes, I have already taken steps.
What is the offense?
Offense, my lord, misappropriation, ground is misappropriation.
Is it a vigilance matter?
No, CBI.
CBI. Okay, you give it.
My lord, Lordship may kindly fix a date so that
Right.
it can be
It will be added to the hearing list. We'll see that there.
2008.
Okay.
Pardon to mention, my lord. Fresh admission, 3 years conviction, my lord. My lord, I may pardon, but Lord Special has given time, interim bill till 30th. Yesterday, one of the co-appellant has been granted. Defect free, two more.
Defect le masivani.
No, defect free.
Pardon to mention that myself, item number 104, my lordship. That has a weekly list, my lordship. The informant has already matter has been compromised between the informant and the present person, my lordship. So, my lord, today, my lordship, last week, my lordship, I have already mentioned, my lordship.
Okay.
Not,
We'll see that if time permits, we'll take up.
My lordship. Item 104, my lordship.
Yes, sir.
Item 224. Others inless, I filed IA. Let's keep it. Last case if possible.
Instruction has been taken.
हाँ,
कौन फाइल टा नहीं
224.
मिस्टर मिश्रा
Mr.
त्रिपाठी से कौन को फाइल टा को ना हाँ नहीं मगेलियन.
Pardon to mention, Your Lordship. Item 219 of the list yesterday I had mentioned, Your Lordship. You are seeking modification of the condition of the bail, Your Lordship. She has been directed to. Am I audible?
Yeah.
She has been directed to deposit a certain amount, out of which she has already deposited 50%.
Okay.
Now, Your Lordship, she has come up with various illness, Your Lordship.
Mark
All right, pardon me, Lord. Criminal appeal, out of 10 years, 8 years already sentenced.
Pardon to mention, my lord, on criminal appeal number 98 of 2018, my lord, he is in 8 years custody, my lord. I'm filing a new phrase, Bhinama, my lord. It may be accepted. And
for what purpose you are mentioning?
For bail, my lord.
Bail.
Yes.
What is the sentence imposed?
20 years, my lord.
Out of 20, you have undergone 8 years.
Yes.
Give it.
Your Lordship, criminal appeal arising out of SC/ST case, Your Lordship, for fresh admission. I've mentioned it several times. Your Lordship, another prayer also, item 90 of the weekly list, Your Lordship. We have filed an interim application, this case for bail, Your Lordship. In the meantime, the son of the present petitioner, present appellant has been taken seriously ill, Your Lordship. Your Lordship had also called for a report since this is an after conviction matter.
Item
Regular bail ଅଛି କିନ୍ତୁ ସେଇଥିରେ ଆମେ ଗୋଟେ prayer ବି ରଖିଛୁ. Item 90.
90.
May I pardon my
Much
lord?
obliged, Your Lordship. 90.
Yes.
Much
May I
obliged.
pardon, man? Regular list, weekly list, my lord, 251. In place of criminal appeal, the matter has been filed before this honorable court as criminal revision. That's why
Which
delay
item you are mentioning?
delay is committed.
Which matter item number?
251. Yes, ma'am.
What is this criminal appeal for?
Against the conviction. 2 years, 6 months.
Just a minute.
Pardon to mention, Your Lordship.
So, what is the conviction and what is the sentence?
2 years, 6 months.
For the offense?
Offense 452, read with 34, and under section 323, 427.
You are on bail, all of you?
Yes.
Right. What is the delay pointed out by the staff reporter?
For wrong filing.
81 days. Other defects are removed.
Yes, ma'am.
Yes, Mr. 81 days, it's a case of conviction. For condonation of delay, he is making the prayer. IN number.
111.
Yes.
One. Yes, ma'am.
You are mentioning item number 251, na?
Yes, ma'am.
The delay is pointed out 81 days. IA number 2204 of 2023. This is an application for condonation of delay. The stamp reporter has pointed out that there is delay of 81 days in filing the criminal appeal. After hearing the learned counsel for both the parties and going through the averments taken in the interim application, and since it's an appeal against the order of conviction, and substantive sentence of 2.5 years have been imposed on the appellant, I am inclined to condone the delay. Accordingly, delay is condoned. IA is disposed of. I'd admit he was on bail. Bail granted. Stay realization of fine.
Urgent side.
Yeah.
Oblige. Pardon to mention your lordship. Lordship, item 381 of the weekly list only. Lordship.
381.
Your lordship.
You are mentioning Friday list. Wait till Friday.
Yeah, please. Item number 3 million supplement list. Permitted to. This is infrastructure matter. But item number 169 of the weekly.
Just a minute. Item number 3 files a memo. Withdraw the criminal appeal. Supplementary. Withdrawal memo is on record.
I may pardon my lord.
Item number 169 of the weekly list, your lordship. In this case, lordship granted 3 months interim bail. Lordship may direct the state to take instruction whether it's surrender in time or not, because he could not be able to contact. 169 jail criminal appeal 99 of 2018, your lordship.
$99
of 2018, your lordship. Mahadev Batra.
Are you aware that he has availed the
my instruction is surrender in time. Availed the bail and surrender in time, but he could not give the
SCRLA. This is item number 169. The learned counsel for the petitioner appellant submitted that he has received instruction that after availing the interim bail period, the appellant has surrendered in the trial court and he has been taken into judicial custody. Since the surrender certificate has not filed, let instruction be obtained from the learned trial court in that respect. For such purpose, file be placed before registered judicial. Order for them.
I may pardon my lord.
Which one? अच्छा से 98 रे मध्य से नहीं आसन होला whether appellant surrendered or not. How किछि
I may pardon my lord.
अच्छा हो सेटा मध्य नहीं आसन तो whether okay.
I may pardon my lord.
Item number 214, my lord. Weekly list. Weekly list 214, my lord. Item CRLA number 70 of 2018.
214.
My lord. CRLA number 70 of 2018. In this case, my lord, I have filed an IA for bail, my lord. The custody period is more than 7 years, my lord.
What is the sentence imposed?
Out of 10 years, my lord.
So you wait when the matter reaches, it will be taken out. Why are you mentioning?
Not 240 not reached today, my lord.
कौन करा जीवो? आपण आगे नहीं गले आपण को जो भाई भौणी माने सब बसचंती से माने आपत्ति करिवेनी.
If possible, my lord, I will take up last.
All right. Yes.
I may pardon my lord. One anticipatory bail. What is bail application? First disposal by my lord. It has maybe taken up.
Yes.
If possible, my lord, I will take up last.
Number to mark. Yes. Any mention from
Lord, item 209, Lord. It's a bail under the SC/ST Act. Notice to go.
Just a minute.
209. 209.
What do you want?
Notice may be issued. Date may be fixed. First week of.
Notice has not been issued.
Notice has not been issued. So it is a freshman.
You serve then extra copy?
Yes, Lord.
Since it's one of the offenses 3 SC/ST Act, usual order for them. So extra copy to be served. Notice to be issued. CD. Mr. Mishra.
Well,
item number 209 ta SC/ST matter. Extra copy se debe. CD criminal antecedent, yes. Yeah.
Well, this first week, can it be fixed first week of
The week commencing from 9th October, right?
obliged, obliged.
Yes. Supplementary document.
Supplementary list item number 1.
Yes, Lordship. My Lord, I'm on virtual.
Yes.
My Lord, I just want to indicate two things and leave it to your Lordship. My Lord, that he's been in custody from 26/11/2020.
Just a minute. During course of argument, Yashwant Das and senior advocate for the petition appearing submitted that one of the co-accused, Lalit Kumar Soni, has been directed to be released on bail by the Honorable Supreme Court in so and so, okay, as per order dated so and so. Since the PS case number and GR case number and name of the court not been mentioned in the order of the Honorable Supreme Court, and counsel for the petitioner submitted that the matter may be taken up next week to satisfy this court that the order dated so and so has been passed in connection with corresponds to, okay. Submits that he has received the copy of the bail order of Lalit Kumar Soni and seeks some time to verify regarding claim of verity. Yes, Mr. Das, I have gone through it.
Yes, my Lord, I am being called in a matter. My Lord, my learned friend will explain to my Lord. My Lord, I want to just indicate one thing, that Lalit Soni's case, it was not for merits have not been gone into only because of the fact that long incarceration and the delay in the trial, they have been granted bail. And my Lord, have in similar matter of this very petitioner granted bail in 6/9/2022.
No, I just wanted to know that whether that Lalit Soni was granted bail in this particular case or not. That
yes,
is
this
Mangalabad
particular case. My learned friend is there, Mr. Mahanti is there. My matter is, may I be permitted to go, my Lord? My matter is reaching.
All right. Yes.
Lalit Kumar Soni has been granted bail in Mangalabad case number 297 of 20 by the Honorable Appeals Court in criminal office number 2366.
How can I know it? Please show the bail order. Or Lalit Kumar Soni order ta dele.
ସେ ବେଲ୍ ଅର୍ଡରରେ କିଛି ନାହିଁ, ଆମ ସୁପ୍ରିମ କୋର୍ଟ ବେଲ୍ ଅର୍ଡର ନାହିଁ।
ଆପଣ ତ ସେଇଥିପାଇଁ କୁହାଯାଇଥିଲା ଯେ କେମିତି ଆମେ ଜାଣିବୁ ଯଦି ଗୋଟେ ବେଲ୍ ଅର୍ଡରରେ PS କେସ୍ ନମ୍ବର ମେନସନ ହଉନି, GR କେସ୍ ମେନସନ ହଉନି, ଆଉ କୋର୍ଟ ନା ମେନସନ ହଉନି, ଆଉ ସେଇ ଲୋକଟା ନାଁରେ ଅନ୍ୟ କେସ୍ ମଧ୍ୟ ରହିଛି, କେମିତି ମୁଁ ଜାଣିବି ଯେ ଏଇ ପର୍ଟିକୁଲାର କେସରେ ତାକୁ ବେଲ୍ ମିଳିଛି ବୋଲି?
PLAPL number has been indicated in the part.
କୋଉଟା କହିଲେ?
PLAPL number has been
PLAPL 6419 of 2022 order against ରେ ଆପଣ ସୁପ୍ରିମ କୋର୍ଟ ଯାଇଥିଲେ, ତ ଏଇ BLAPL ଅର୍ଡରଟା କୋଉଥିରେ ପାସ୍ ହେଇଛି କେମିତି ଜାଣିବି? ସେଥିପାଇଁ ପରା ମୁଁ ସେଦିନ ଭେରିଫାଇ କରି ଦେଖିଲି। ରେକର୍ଡ ଆସିଛି କି? ଏ ରେକର୍ଡଟା ଦେଖି BLAPL 6419 2022 ଆସିଛି ରେକର୍ଡ ଦେଖି।
এইটা তো 6 আরে এইটারে ଅଛି ନା এইଥିରେ ଅର୍ଡରଟା ନମ୍ବର ଅଛି ବୋଲି।
Yes, Mangalabad PS case number 297 2020 GR 1504 2020 pending in the court of CGM. But okay, এটা বন্ধ করে দিয়ে ঠিক পড়ে আসো। 6919 bus. Right. 150297. All right. So, Mr. Tripathi.
Yes, Muller.
That order of the Honorable Supreme Court has been passed in this particular case, and what is the why he was granted bail on
Delayed trial?
Just let me see that. Those ones. So this petitioner name is Saroj Kumar Pusti.
Yes.
Saroj Pusti and this Lalit Soni, they stand on the same footing.
Yes.
Saroj Pusti, Lalit Soni. And what is the date of custody of the Lalit Soni and what are the date of custody of this petitioner? Mr. Mahanti?
Same date, madam.
No, same date. Petitioner was taken into custody since when?
19/1/21, he was remanded in this case.
19/1/21.
21, remanded.
What about Lalit Soni? Earlier bail application of this petitioner was rejected in which application?
My lord, that is a connected batch of bail application. That is 1887 of 21.
1811 of 21.
1811 of 21 of the present petitioner. My lord, the main order, the common order was passed in BLAPL number 1887 of 21. That has come, my lord.
সেটা কাই সে রেকর্ডটা কাই 1887.
Okay.
So about the allegation which is leveled against the petitioner, that is Saroj Kumar Pusti is in page number 13, 14.
Yes, sir.
Okay, and Lalit Soni could page
Page
right?
16.
16.
16.
16, okay.
Page 10, my lord, your lordship has observed. During investigation, it was revealed that the petitioner Lalit Soni and Saroj Kumar Pusti made several transactions in their accounts with Manapuram. Allegations are same.
Allegation, not date of custody.
ने डेट ऑफ कस्टडी आपनकर एफआईआर ना ये जो फाइनल फॉर्म में थिबो ना
ललित सोनी
आपन फाइनल फॉर्म में देखुना दी मंगलाबाग पीएस केस नंबर 297 ऑफ 2020 तार फाइनल फॉर्म टा बाहर करंदो फाइनल फॉर्म में गोटे कॉलम रहउची केबे अरेस्ट हेले केबे फॉरवर्ड हेले सेथुरु देखि कोन तो पिटिशनर केबे is it that date is correct 19/1/2021 he was taken on remand have you mentioned in your bail application
in the note
अपन पैराग्राफ 5 रे लिखचंदी 27/11/2020
in Lalbagh PS case number 294 of 20.
आ गोटे केस ए केस रे रिमांड नेले 19/1/2021 okay are the learned counsel for the petitioner learned counsel for the state the learned counsel for the petitioner submitted that the petitioner earlier approached this court for bail in BLAPL number 1811 of 2021 while the investigation was under progress and this court by order dated 6/12/2021 has been pleased to reject the bail application. One Lalit Kumar Soni, who is similarly situated, also approached this court for bail in BLAPL number 3189 of 2021, and his bail application was also rejected on the very same day by common order. And in the meantime, Lalit Kumar Soni has been released on bail by the Honorable Supreme Court in Criminal Appeal number 2366 of 2023 as per order dated 9th August 2023, which arises out of SLP criminal number 11086 of 2022. Mainly on the ground that mainly on the ground of delayed disposal of the trial. And therefore the petitioner's bail application may be favorably considered on the ground of parity and equity. The Learned Counsel for the state, after verification of the case record, fairly submits that the petitioner is similarly situated like the co-accused Lalit Kumar Soni. Considering the submission made by the Learned Counsel for the respective parties, the remand date करने के लिए अच्छा रेट लिख दें the Learned Counsel for the petitioner से जो तांकर contention रखे he was say paragraph number 5 रे लिख जंदी केबे custody के नेले in connection with another case, but he was taken on remand in this case on 19/1/2021. Hello? Considering the submission made by the Learned Counsel for the respective parties, period of detention of the petitioner in judicial custody, trial एपर्यंत आरंभ ही नहीं and अच्छा सेट लिख दें तो only 7 witnesses have been examined. What is the total number of witnesses?
15.
50 out of 15 out of 15 witnesses, 7 witnesses have been examined. Slow progress of the trial, and since similarly situated co-accused been released on bail, and now the case is these offences are all magistrate tribal offences, Mr. Tripathi, and the offences are tribal by magistrate. I am inclined to release the petitioner on bail allowed.
Item number two.
This accused Raju Kishore in CRLA 260 of 20, my lord, he is in the jail custody since 21st November 2016, and in this NDPS case, he was convicted, my lord, on 20th February 20, and now already nearly 6 years, 9 months have elapsed, and he has a good ground also to succeed because there is no consent.
What is the date of custody?
My lord, since 21st November 2016, it is in the judgment also revealed. And the judgment was on 20th February 20 at Noyagarh jail. Pray bail me kindly.
The appellant is Raju Kumar Kushwa.
My lord, Raju Kumar Kushwa.
You are never released on bail by the...
Never, Your Honor, during the trial or even thereafter. Not released on bail.
You are a man from Bihar.
My lord, is a man from Bihar.
Whether the address verification has been made?
No, it has not been made. Maybe made. Verification.
Council. You are Mr. D.P. Patnaik.
My lord, I am D.P. Patnaik from Dhanabadan.
D.P. Patnaik, Land and Council, appearing virtual High Court on Go, submits that the appellant Raju Kumar Khushwa was taken into judicial custody in connection with this case on 21/11/2016, and he has never been released on bail during trial or during pendency of this appeal, and therefore he has already undergone substantive sentence of more than 6 years, 9 months, or 10 months?
10 months.
10 months.
November 16. 10 years.
Since the substantive sentence imposed by the London Trial Court is 10 years, and there is no likelihood of the appeal being taken up for hearing in the near future, the bail application may be favorably considered. London Counsel for the State, on the other hand, submitted that the petitioner is a man from state of Bihar, and he may be given some time to verify the correctness of the address furnished in the cause title. Considering such submission, let the Superintendent of Police Nayagarh make necessary communication with the Superintendent of Police Motihari district in the state of Bihar to ascertain the correctness of the address furnished by the appellant in the cause title. The matter will be listed in the week commencing from 9th October 2023. Free copy of the order be handed over to the London Council for the state for compliance. Yes.
Same item, sub item, criminal appeal number 230 of 2020.
Yes, sir. This man is also?
No. He is on good.
On good. Okay, what is the detention period? Same period? Have you obtained the custody certificate?
No.
So you obtain? ଆଗରୁ ବେଲ୍ ହେଇଗଲେ ସେ କହିବେ ମୁଁ ବେଲ୍ କରେଇଦେଲି ହେଲା ନେଇ ଆସନ୍ତୁ କଷ୍ଟଡି ସେଇ ଏକା ଡେଟ୍ରେ ଆସିବ 9th October 2023. Yes, next.
Item number 4.
Which one?
Item 2, sub item.
Prisoner's petition at flag H, praying for engagement of Ramesh Chandra Maharana.
Yes.
So your name is there. What do you want? No, you have filed Wakalat Nama, na?
Yes.
You want the other names to be deleted? Is a sole appellant?
Sir.
Okay. In view of the prisoner's petition filed for engagement of Ramesh Chandra Maharana. Ramesh Chandra Maharana na Ramesh Maharana? Ramesh Chandra Maharana as his counsel. And since Mr. Maharana has already filed Wakalatnama for the appellant, the names of Prashant Kumar Sahu and his associates shall not be reflected in the cause list henceforth. এটা extension দিয়ে দেবে 4 নম্বরটা extension দিয়ে দেবে যাহা মাগিছেন সে. Yes, next.
Item 5.
Number be corrected.
Inadvertently the typed out as instead of acha. Dion.
Well, at 3, item 3.
It's a withdrawal memo file करते.
What is he was on interim bail?
Okay.
This petitioner.
अच्छा से 3 नंबर टा अपन लिखि दियंतु हाँ से कोन इंटरिम बेल रे थिले ए देखिले 3 नंबर टा मेंशन करछन कहिलेनी सेते बेले wait 3 months थिला इंस्पेक्टर फ्री कॉपी ऑफ दिया डिस्पोज ऑफ ये छी ना तो क्रिमिनल अपील बेटा हाँ ओके तादेर खाली ऐड कर दियंतु since the appellant Shatrugna Singh was granted interim bail for 3 months as per the order dated 6/12/2021 in IA number 480 of 2021, comma, if he has availed the same, and not surrendered in time, the London Trial Court shall take steps in accordance with law for his arrest as well as institute appropriate proceeding against the bailers. Order copy be communicated to the London Trial Court by the registered judicial. Yes, next.
Only number be correct.
Yeah.
Sure.
Item 6.
এটা কোন হবো 2021 বনা তো এইটাକୁ ନାଲି ପେନ୍ ରେ କାଟିଦେଲି ତାକୁ ଲେଖିଦେବେ ଆଜି ତାରିଖ ହେଲା 26 ତାରିଖ ନା 26/9/2023 ନିଅନ୍ତୁ ଏଇଟା ସେ ଅର୍ଡର ରହିଗଲା ଯୋଉ ଆକ୍ୟୁଜ୍ଡ ବେଲ୍ ଅର୍ଡରଟା ସୁପ୍ରିମ କୋର୍ଟ ଅର୍ଡର ଏଇଟା ନିଅ Yes.
Lords, I have filed this IA seeking further release on interim bail because I have not yet been able to collect those, the entire antecedents which I have said to have. Lords, at the trial, it was stated by the IO that there are 22 antecedents against the appellant. So your lordship directed me to furnish status report. Now, because of the fact that I am ill and I could not collect the entire status and your lordship was pleased to release me on interim bail. Now I have surrendered to custody and have prayed for further extension of interim bail.
You are granted interim bail for a period of
2 months.
2 months, right? That was the order dated 18/7.
17/7.
18/7.
Prior to that also your lordship has granted.
So, you have surrendered.
Yes, I have annexed the surrender certificate, annexure.
Surrender certificate. Now, which application you have filed now?
This is IA 2301.
2301.
Same ground has been taken, madam.
In view of the opposite sounds interview. Languishing has been suffering from oral cancer. He has undergone surgical operation and is undergoing so. He is yet to recover so. Medical papers he has given.
Already on the last occasion, detailed report was given, my lord.
On the basis of that,
he was granted
interim bail. Detailed report.
ନାଇଁ ନାଇଁ ଏଇ ଯୋଉ ମେଡିକାଲ ଡକୁମେଣ୍ଟଟା ଦେଇଛନ୍ତି ଏଟା କେବେକାର? Wait, just a minute. Let me see.
24/7.
Where is the no, Mr. Panda? It is 4th September 23.
ଆଜ୍ଞା ଗୋଟେ 4th ସେପ୍ଟେମ୍ବର ତା ତଳେ 24/7.
ହଁ ତ ଆପଣ ଆ ଭିତରେ ଆଉ ଉପରେ କେମିତି ଇନଷ୍ଟ୍ରକ୍ସନ ନେଇଗଲେ?
ହେଲା
4th ସେପ୍ଟେମ୍ବର ର ଡକୁମେଣ୍ଟ ଉପରେ ଆପଣ କେବେ ଇନଷ୍ଟ୍ରକ୍ସନ ଦେଲେ?
13/7 minutes previously.
ଏଇ ଯୋଉ ଡକୁମେଣ୍ଟଟା ସିଏ ବର୍ତ୍ତମାନ ଫାଇଲ କରିଛନ୍ତି ଇଣ୍ଟ୍ରିମ୍ ଆପ୍ଲିକେସନ ସାଙ୍ଗରେ ସେ ମେଡିକାଲ ଡକୁମେଣ୍ଟ ଇଜ ଡେଟେଡ 4th September 23. When I am going to pass an order that please take instruction, you said that I have already taken instruction, detailed report has been prepared. How can you take instruction on this?
Earlier,
Maybe. So what is it? Don't make such submission. Take instruction and we'll.
Yes, sir.
Look on the code was SC medical. Look on this IN number 2301 of 23. This is an application for interim bail on the ground of ailment of the petitioner, and it is stated that the petitioner is suffering from oral cancer and he has undergone surgical operation and is undergoing further treatment at Acharya Harihar Post-Graduation Institute of Cancer, Cuttack, and had undergone chemotherapy and further follow-up treatment is required, and he is yet to recover and is unable to eat, for which is unable to eat stuff. Medical document in support of the averment has been annexed to the interim application, which is dated 4th September 2023. The Land Council for the state submits that he has received the copy of the interim application along with the medical document, and the matter may be taken up next week. Raghuji, next week, in order to obtain instruction, list this matter. We commencing from 3rd October 2023.
Instruction to be taken from Nimapada jail.
अरे SCB मेडिकल कॉलेज डॉक्यूमेंट ऑथेंटिक आपण डॉक्यूमेंट देखि जन ना नहीं हाँ से डॉक्यूमेंट ऑथेंटिक नहीं और आसचला ना नहीं भलिया पेशेंट चिकित्सा यार कंडीशन कोन एई तो इंस्ट्रक्शन नेबे ए डॉक्यूमेंट को देखै कि ना कोन हला आपण डॉक्यूमेंट दिया छि मेडिकल डॉक्यूमेंट यस नेक्स्ट
Yeah.
Item 7.
My lord, item 7. Your lordship was pleased to direct me
Item number 8.
Please, Your Lordship. Lords, here I have filed an IA praying for suspension of the sentence of the conviction, my lords. And my learned friend for the vigilance has filed an objection to it.
Objection is.
Lordship, Your Lordship will look at my IA. At paragraph 3, I have stated the reasons for which I seek suspension of conviction.
This is IA number.
IA 1398.
All right. It's a trap case.
Yes.
What about the decoy and overhearing witness?
Decoy, that is on the basis of the decoy's evidence that the conviction has been sustained because the informant died, my lords. My submission is that the evidence on record also is not sufficient to establish a case of demanded
the complainant died.
Yes, my lords.
So now the only remains the overhearing witness.
Yes.
That overhearing witness has been examined as
PW2.
What he has stated.
This PW2 I have stated in my IA also, my lords, that he has stated that he has seen the transaction, my lords. But in cross-examination, he has admitted that he cannot say the exact verbatim of conversation between
No, you come to deposition paragraph 4 of PW2.
My lords, just a moment. Your Lordship may see what he says at para 4. In the third line I am placing, we noticed the accused was available in front of the room of the vice chairman. On seeing the presence of Milu Rai, accused called him and inquired about the money. And on receipt of positive indication, complainant delivered the amount after collecting it from his shirt pocket. Accused collected the amount by his right hand, counted the same by both hands, kept it inside his pant pocket. Immediately thereafter, accused left towards the office of ICDS Gonia, and at that time, I relayed the message by rubbing my forehead. Thereafter, my lords, he speaks of the trapped inside.
The accused was apprehended at what place? Because he left the office.
He was apprehended, my lords, immediately at that spot, my lords. Inside the computer room of ICDS office.
Okay. And that amount was recovered.
Yes, amount was recovered.
And what he has stated, you said that in the cross-examination?
Cross-examination, my lords, may look at para 8.
Para 8, yes.
If your lordship will see that paragraph, my lords, he says in the second line, on 21/12/09 between 4 to 5 p.m., I received the order to appear before the vigilance office at Nayagarh. The IO never seized copy of the order from me. ତାପରେ ଆଜ୍ଞା ଦେଖନ୍ତୁ paragraph 10, my lords. I cannot say the exact verbatim of the conversation made between the accused and the complainant. ତା ଉପରୁ ଆଜ୍ଞା ସେ ତାର ଲୋକେସନ ଟାକୁ ବି କହିଛି para 9 ର end ରେ. He has stated, if your lordship will look at para 9, 1, 2, 3, 6 lines from the bottom, accused was available on the veranda in front of the room of the vice chairman at the time of our arrival. Transaction took place on the said veranda. I cannot say if it is mentioned in the detection report that the transaction was made at the veranda adjoining vice chairman's room. No rooms were available on the other side. I was available at the veranda at the time of transaction, about 4 to 5 feet away from the complainant.
Okay, but when it was recovered from you,
My lords.
so questions must have been put to you on the in the 313.
Yes, my lords. Now your lordship may look at the 313 CRP system.
313 statement bar karo.
Relevant question is question 11. It further appears from the prosecution evidence that on seeing the informant, you inquired about the bribe money. Thereafter, the informant handed over the tainted money to you after collecting it from his shirt pocket, which you received by your right hand by counting the same by both hands, kept it in your pant pocket. Subsequently, witness Narayana Murmu had given the signal to the traffic.
No, that you said false. I am telling about the recovery of on explanation. Come to question number 21.
Question 21, he says, in the year 2009, informant was the tuition teacher of my daughter. He had taken hand loan from me amounting to rupees 2000, but he had not repaid the same, and he adjusted rupees 200 as his tuition fee for the month of November and told me to pay 1800 to me. On the day of occurrence, informant had given me rupees 1800, but it was not the bribe amount. He had repaid his loan amount to me.
You accept that you have taken that money,
yes,
but that was for some other purpose,
yes,
right? So in the year
my
2000,
further submission, my lords, further is that from the evidence on record, my lords, the ingredients of section 7 and 13 are not made out pre-amended section 7 and 13. Because the only evidence of this overhearing witness is that
taken the amount into rupees 3,000.
Accused called him and inquired about the money, and on receipt of positive indication, complainant delivered the amount. This is one part, my lords.
Okay. And he was also examined as DW1.
Yes.
Rabindra Kumar Behera. Rabindra Kumar Behera ki?
No, Rabindra Kumar. This accused is S.K.SAHOO.
No, Rabindra Kumar Behera has stated about this tuition thing.
He is the defense witness.
I am telling you about. Come to the defense witness.
Rabindra Behera's statement is
DW1.
He says at paragraph 1 itself, from the fourth line, by profession, the informant was a tutor and he was giving tuition to different students, including my daughter. He was also giving tuition to daughter of the accused. In the month of January 2009, he was taking his tuition fee as rupees 200 for each of his students. In the month of June 2009, informant requested me to pay him rupees 2000. Then he subsequently demanded the same amount from the accused, as I was not capable to pay him such amount. The informant was demanding such hand loan for the purpose of the marriage of his bhonaja. Thereafter, in spite of repeated demand of accused, the informant deferred to pay the said amount on different pretexts. Since from the month of November, the accused preferred not to pay the tuition fee of the informant. As such, he started saving rupees 200 each per month towards the loan of the informant of rupees 2000. This talking took place in the month of December 2004. On 3rd December 2005, accused demanded rest amount of 1800 from the informant. Subsequently, I went outside my village for the purpose of driving, and on return to my village, I was informed by my wife that informant had falsely foisted a case against accused. When I met informant, he disclosed that he has committed a mistake by filing a case against accused, and he has done as such at the instance of Sarpanch. Witness volunteered that it was in the year 2009 and not in the year 2004 or 2005.
Yes, Mr. Das.
There is one other thing I would like to urge. My lords, nowadays, the sanctioning authority is not being examined. Your lordship must have seen a trend has come in that the sanctioning authority has not been examined, and the chemical examiner is also not been examined. Now, in this case also, the sanctioning authority was not examined. That is one ground I have taken. If your lordship will look at the accused statement, question number 17 may please be seen. The question reads like this. It further appears from the prosecution evidence that PW7 had attended the pre-sanction discussion with Collector Noaggard, so-and-so, on 7/10/2010, and the Collector Noaggard had accorded sanction of prosecution against you. She, being your removing authority, said sanction order has been exhibited against you as Exhibit 20. This is the question. Your lordship may mark the date of the pre-sanction discussion put in the 313 statement, 7/10/2020. Now, this has been proved by the IO. I'll ask your lordship to kindly look at that evidence, my lords.
Whose evidence? IO?
The IO's evidence with regard to that part. The IO is PW7 Horopriya Naik.
On 4/10/2010, pre-sanction discussion was made.
My lords may look at her evidence in the first paragraph, my lords, second page of the evidence, my lords. Yes. Your lordship may see from the bottom of the second page, 7 lines from the bottom. She says, I have attended pre-sanction discussion with Collector Noaggard, Dr. Mrinalini Darswal, on 7/10/2010 and produced all the relevant documents of the case to her for her perusal and independent opinion. On 19/10/2010, I received the sanction order of Collector Noaggard, while letter dated 5/10/2010, Exhibit 20. Exhibit 20 is the sanction order of the Collector Noaggard. And Exhibit 20/1 is the signature of the then collector. Then, my lord, she says further, this is the forwarding letter number 1067 dated 5/10.
But thereafter he says that was not on 7, but it was
now
on
your lordship may see, again the witness has deposed that on 4/10/2010, pre-sanction discussion was made with the Collector Noaggard, and I had produced the required documents for her perusal. On completion of investigation, I submitted charge sheet. Now your lordship may see what she says in the cross-examination about that. In cross-examination, my lords, it has been specifically put to her.
Which paragraph?
I'm just... My lords, further cross-examination of PW7.
Paragraph 8.
Yes, paragraph 8. Exhibit 17, we are not concerned with that. I cannot show any order of SP on the strength of which we received the facsimile seal from him. SP had issued the requisition for making pre-sanction discussion of the IO with the sanctioning authority. As such, I had not issued any such requisition. All the letter communication with the sanctioning authority were done by the SP. Letter of the sanctioning authority fixing the date and time of making pre-sanction discussion is missing in the instant case record. My lords, I have got one submission to make. Sanction, my lords, is necessary, my lords, for prosecution. For that, my lords, the sanctioning authority is to be examined. Now, this lady in her examination in chief has nowhere stated, my lords, that the sanction order was prepared in her presence. It was signed by the sanctioning authority and handed over to her. How does she prove the sanction order, my lords?
No, say, why did you admitted it without objection? It has been marked. Come to exhibit 20.
I agree.
So that this
no,
is
exhibit 20 is with objection.
With objection.
সেটা দেখুন তো
with objection.
20 and 20/1 both are with objection.
Okay, okay. Yes, Mr. Das.
And Mr. Das has not replied to what I have stated in my IA in his objection affidavit, which is sworn to by the holding IO. He has simply made a Mahabharata of what is going to happen, what will happen, and how corruption is going to be checked by him and his officers.
Mr. Das,
my lord,
complainant is dead.
Yes.
Right. So now you're, so far as prior demand, that cannot be proved by anyone, right? So only on the date of draft, the demand aspect has been stated to by the overhearing witness who has been examined as PW2, and that apart recovery is there. These are the so he has stated about this PW2 about the demand,
acceptance and recovery.
Right. Now, what he has stated, paragraph 4, that on seeing the presence of Milu Roy, the accused, called him and inquired about the money, and on receipt of positive indication, the complainant delivered the amount after collecting it from the side pocket. So this much he has stated, and in the cross-examination, Mr. Panda has pointed out that he said that he cannot say the exact verbatim of conversation between so and so. So if this part is not there and the other part, that about the acceptance and recovery, is there, and what he is offering some kind of explanation, defense plea, that it was not, he's not disputing about the acceptance and recovery because he's taking a plea. So the only question is that if you prove that it was not a demand for that, the loan amount which he has taken the plea, it is for this bribe, then obviously the other thing is not disputing matter is different. So how do you say that?
My lord, my submission before your lordship is this appellant petitioner has been dismissed from service from 27/6/2023, for which the application was filed for stay of the conviction in order to continue in the job. So whatever submissions have been advanced by my learned friend relate to the merit and demerits of this appeal, which are liable to be decided at the time of final hearing of the appeal, not at this stage of 389 application consideration. And besides the decisions which I have mentioned in my para, this decision also I have, your lordship is aware that this decision, all these aspects, 2023-91 OCR, Supreme Court, page 84, while
Paragraph 33 may kindly be referred to. Om Prakash Sahani, Joy Shankar Chaudhary and another, etc. Paragraph 33 may kindly be referred. Last sentence. Paragraph 33. The appellate court should not reappreciate the evidence at the stage of section 389 CRPC and try to pick up few lacunas or loopholes here or there in the case of prosecution. Such would not be a correct approach. 34. In the case at hand, what the High Court has done is something imperceivable. High Court has gone into the issues like political liability, delay in lodging FIR, some overwritings in the first information, etc. All these aspects will have to be looked into at the time of final hearing of the appeals filed by the convicts. Upon cursory scanning of the evidence on record, we are unable to agree with the contentions coming from the learned senior counsel for the convicts that either there is absolutely no case against the convicts or that the evidence against them is so weak and feeble in nature that ultimately, in all probabilities, the proceeding would terminate in their favor. So now, at this stage, your lordship's observation I have relied on, and also I have filed that citations. Your lordship may kindly have a glance to that my objection paragraph. Your lordship's observation at this stage, it cannot be said in page 7 of my objection. This Ponchanan Sahu Prithvilaj link by serial number 8 VII X and XII Pradeep Shanti. Your lordship have observed that at this stage, while considering the application under section 389, it cannot be said that there is no case or some are in favor of the appellant while considering the application under section 389 CRPC. Besides that, whatever my learned friend submitted, I am referring to that which have already been discussed by the learned trial court in the judgment. I am referring to that. Your lordship may kindly have a glance to judgment page 29. The paragraph 11 towards bottom.
Page 29.
Running page 29, internal page 20.
John, take care of 20 bar kala. Page to the
Para 11 is the evidence of PWT.
Para 11.
Para 11. In the instant
case, PW2 Naran Murmu has deposed as the overriding witness. In absence of the informant, he becomes the most vital witness to prove the demand and acceptance of the gratification in question. Worth noting here that the stand of prosecution is that this witness was present with the informant and had witnessed the transaction in question. PW2 has deposed that on 22/12/2009, he was the assistant engineer, rural work subdivision, Daspala, and on that day, on the requisition of SP Vigilance Bhubaneswar, and executive engineer had directed him, and as such, he attended the official office of DSP Vigilance Unit Noyagarh. He has further deposed that the complainant Minlu Rai was present, and that VSP Vigilance introduced him with the complainant, and that Inspector Srinivas Padi read over the complaint lodged by Minlu Rai, and that it was the complaint of Minlu Rai that the accused has demanded bribe money of rupees 2,000 to issue work order for construction of platform around the well, and that after negotiation the complainant agreed to pay an amount of rupees 1800 on 22/12/2009. He has further deposited para 3 of his evidence that the complainant had produced the bribe money of rupees 1800, 3 currency notes each with 500 denomination and 3 currency notes each with 100 denomination, and that I verified the currency notes, and that the vigilance constable had shown the demonstration about the phenolphthalein powder and sodium carbonate solution. This witness has exhibited the preparation report by Exhibit 2 and his signature on it by Exhibit 2/1, and has corroborated the contents of Exhibit 2 at para 3 of his evidence. He has further deposed specifically about the treating of the bribe money produced by the informant with phenolphthalein powder, and about keeping the same inside a 4-fold paper, and about keeping the 4-fold paper in the left side side pocket of the informant. At para 4 of his evidence, this witness has deposed that after preparation report, they proceeded to the block office Gonia and he along with the informant proceeded to block office. Gonia by what? Whereas the other members of the team followed them as per the discussion by the exhibit 2. PW2 had specifically deposed at para 4 of his evidence that we noticed the accused were available in front of the room of the vice chairman, and that on seeing the presence of Millurai informant, the accused called him and inquired about the money. And that on receipt of positive indication, the complainant had delivered the amount after collecting it from his shirt pocket, and that the accused collected the money by his right hand and counted the same by both hands and kept it inside his pant pocket. Immediately thereafter, the accused left towards the office of ICDS, Gonia. And at that time, I relayed the signal by rubbing my forehead, and that the team members came and inquired from me about the transaction, challenged the accused, who first denied but thereafter admitted to have received the money. PW2 has further deposed that the accused was challenged inside the computer room of ICDS office. The right hand wash and left hand wash of the accused was taken separately in sodium carbonate solution, which turned to pink, and the same was kept preserved in glass bottle with proper seal. The accused thereafter handed over the tainted money to Jagdish Prasad Maji, who tallied the currency notes with preparation report and found it to be correct. The right side pant pocket wash of the accused was also collected in sodium carbonate solution, which turned to pink. During this, besides that, your lordship asked that the complainant was dead. The Lorraine trial court has taken into consideration of the decision of that Nirav Datta case. In paragraph 10, your lordship may kindly see, he has observed, in the event the complainant turns hostile or has died or is unable to late in his evidence during trial, demand of illegal gratification can be proved by letting in the evidence of any other witness who can again let in evidence either orally or by documentary evidence, or the prosecution can prove the case by circumstantial evidence. The trial does not abet, nor does it result in an order of acquittal of the accused public servant. The Lorraine trial court has observed this thing, and I have relied on, my lord, the decision in my objection. So, my lord, at this stage, whatever submission have been made, all these factors are to be considered at the time of final hearing of the appeal, my lord. It is not the stage to be considered the evidence scrutinized, and if anything anything is taken now, it may impact the final hearing of the appeal, my lord.
All right. So no, what Mr. Panda is trying to impress upon that let us accept PW2's evidence. 2 number साक्षी आपनकर कोन कहला से जो मेन पार्ट टाको जे मु जेते बळे देखिली आसंद आउथर से एविडेंस को पड़े आसंद जे we noticed that the accused was available in front of the room of the vice chairman.
Yes, ma'am.
Stop there. On seeing the presence of the informant, the accused called him and inquired him. एगुड़ा सब एक्सेप्ट करनी होनी.
Yes, ma'am.
सी ताकू कहिला टंका कथा कहिला एवं सी सेठू पॉजिटिव सिग्नल देला अर्थात मु आनिची बेली कहला एवं ताकू से हैंडओवर कला हैंडओवर करिकिनी कला पर से ताकू नहीं निज पॉकेट रखला. एगुड़ा को सब आपण जहा कहजन लेट अस आपनकर ओवर हियरिंग विटनेस को एक्सेप्ट करा जाऊ.
So also PW3. PW3's evidence has also been discussed.
कौन से कोई
Jagdish Prasad Maji, he has also corroborated the story of PW2. He was a magistrate witness.
He was not present there.
As magistrate witness. So I am submitting. Let me submit. PW3 magistrate witness.
कथाटा गुटे सुनिकिनी तापर उत्तर दियंतु. गोटे साक्षी कहिला जे मु देखिली ये ताकू टंका मागिले टंका कथा कहले ये तापर टंका हाँ मारले एवं हाँ मारिकिनी तांकू आनिकिनी से देले से टंकाटा ग्रहण करी रखिले. এই এভিডেন্সটা লেট अस से इट इज अनचैलेंज्ड रिमेन्स. सी गोटे एक्सप्लेनेशन दउछन्ती एटा गोटे ट्यूशन टंका लोन नेइथला अल्ला.
That has been disbelieved. Tuition टंका.
ठीक अछि.
DW1's evidence have been disbelieved by the trial court.
आपण सुनी सारला परे उत्तर देबे ना मझिरे ता देरे ये करी.
Yes, sorry.
तो एतिकी जिंस जदी एविडेंस आसिला सेई जो टंकाटा जोठी से कहिला टंका आनिचंती एवं से कहिला हाँ मु आनिची एवं ताकू देला से ग्रहण कला. How can you say that it's a bribe money or there was a previous demand to do some work? Unless the complainant is examined, how can that part will be proved? If a complainant is dead, unless you establish through evidence that that money was given for this particular purpose, सी तांकर कौन एविडेंस देइचंती सेटा डिसबिलीव हेगला सेगला किंतु आपणकर प्रमाण करिबा तो दरकार ना पुनी जे जो टंकाटा सी ताको पचारुथिला से दिन अक्यूज जो टंका विषय रे पचारुथिला सेटा सेई लांच टंका जो काम करिबा पई से ताको मागिथिला सेटा कहि थांदा कि कंप्लेनेंट
यस
सी तो मरी गला बर्तन से पार्टटा कोठु आसिला केमती प्रमाण करेबे
सेटा PW7 IO your lordship may kindly have a glance to running page 39 judgment. Fourteen A. Work order in question is admitted by the accused. Your lordship got it.
39
running page 39 internal page 30
paragraph kete
14A small work order in question is admitted by the accused but he is disputing that no police sabha was held for its purpose but PW7 being the IO of the case has deposed at para 6 of the upper cross examination that I have seized the letter of Sarpanch in which the Sarpanch had requested to conduct estimate. Notice of police sabha meeting was sent to village Dhobarai for the construction of village well, platform, etc. The date on which the said work is to be executed has not been mentioned in the work order. So this PW7
आपण जो वर्क ऑर्डर इश्यू करिया पई तो से टंका डिमांड करथला तो
हां
तो से एमती किछि काम पेंडिंग थिला
यस
ए जो एविडेंस गुडा का आईओ कहला सेटा का आपण आईओ रो कोन सेटा प्रत्यक्ष ज्ञान अछि तो ताकू अन्य जरिया जदि कंप्लेनेंट आपण हैंडिकैप्ड हे गलानी प्रोसिक्यूशन बर्तन जेतु कंप्लेनेंट मरी गलानी तो एमती गोटे कामर वर्क ऑर्डर पेंडिंग थिला आ पाखरे ताकू अन्य एविडेंस थ्रू रे आनिथवा दरकार थिला ना नाही जे नाही हां तारो ए कामटा पेंडिंग थिला तेणु ओकेजन थिला बा ताकू ता पाखरे वर्क was there for which there was chance of demanding money to execute to do that work.
My lord, when the complainant has died regarding this work order etc. Besides complainant rest TLO and IO because these witnesses who have been accompanying witness and the magistrate witness they were present just to see the trap mile
जदि आईओ कहि दबो
TLO and IO besides complainant
एगुडा को भी एग्जामिन करिया भी दरकार नाही जो आपनकर
no he is the best person my lord as your lordship queried when the complainant has died except the TLO and IO before whom the complainant has described for which purpose the demand was being made who are the best persons the TLO and IO and reason for demand reason of demand so they no except TLO and IO all these witnesses official witnesses were there and brought on requisition only to support the trap and see the trap regarding work order and this etc this TL official witnesses TLO and IO are there. So whatever my submission respectful submission before your lordship that all these things factors are liable to be considered at the time of final hearing of the appeal my lord.
That's all. All right, order reserved.
There's only one thing I will reply.
Yeah.
My
Well, this decision may kindly be taken.
My learned friend refers to that Om Prakash Sahni's judgment, my lord.
Yeah.
There, my lords, that was a case where their lordships were considering suspension of sentence. And in para 33, their lordships say at paragraph 33 that the endeavor on the part of the court should be to see as to whether the case presented by the prosecution and accepted by the trial court can be said to be a case in which ultimately the convict stands for fair chance of acquittal. If the answer to the above said question is to be in the affirmative as a necessary corollary, court shall have to say that if ultimately the convict appears to be entitled to have an acquittal at the hands of the appellate court, he should not be kept behind bars for a pretty long time till conclusion of the appeal, which usually takes
that was a consideration of bail application.
Yes.
Bail application ne ଯେତେବେଳେ adjudication କରୁଥିଲେ ସେତେବେଳେ ମାନେ merit ରେ finding ଦେଇକି
Right.
bail ଦେଇଛନ୍ତି.
Right.
ସେଇଥିପାଇଁ ସେ
ତାପରେ ଆଉ ଗୋଟେ ଜିନିଷ your lordship will keep in mind. My learned friend is harping on Neeraj Datta, that constitution bench. Now the constitution bench decided certain things. Thereafter, Neeraj Datta was heard by a division bench, regular division bench, consisting of Justice A.S. Oak and Justice Rajesh Bindal. Now their lordships acquitted the appellant in that. That is reported in 2023 SCC Online SC page 280. There, what their lordships say is this. Their lordships say like this, that legal position paragraph 8 is like this. Before we analyze the evidence, we must note that we are dealing with section 7 and 13 of the PC Act as they stood prior to the amendment made by Act 16 of 18 with effect from 26 July 18. We are referring to section 7 and 13 as they stood on the date of commission of the offense. Then their lordships quote section 7 and section 13, my lords. And their lordships say, at the demand for gratification and acceptance thereof are sine qua non for the offense punishable under section 7 of the PC Act. The Constitution bench was called upon to decide the question which you have quoted earlier. In para 74, the conclusions of the Constitution bench have been summarized. Their lordships quote that, my lords, that summary. Then what their lordships go on to say is like this. The referred question, para 12, your lordship may see. The referred question was answered in para 76 of the aforesaid judgment, which reads thus. Accordingly, question referred for consideration of this Constitution bench is answered as under. In the absence of evidence of the complainant, direct oblique primary, oral oblique documentary evidence, it is permissible to draw an inferential deduction of culpability guilt of a public servant under section 7 and 13(1)(d) read with 13(2) based on other evidence adduced by the prosecution. Then what their lordship say is like this. That your lordship will see at paragraph 18. Sorry, para 16. Thus, the demand for gratification and its acceptance must be proved beyond a reasonable doubt. Section 7 as existed prior to 26 July 18 was different from the present section 7. Unamended section 7 applicable to the present case specifically refers to any gratification. Substituted section 7 does not use the word gratification but uses a wider term, undue advantage. When allegation is of demand of gratification and acceptance thereof by accused, it must be as a motive or reward for doing or forbearing to do any official act. Fact that the demand and acceptance of gratification were for motive or reward as provided in section 7 can be proved by invoking presumption under section 20, provided basic allegations of the demand and acceptance are proved. In this case, we are also concerned with offense punishable under clauses 1 and 2, section 13(1)(d), punishable under 13(2) of the PC Act. Clause D of subsection 1 of 13, which existed on the statute book prior to amendment of 26 July 18, has been quoted earlier. On a plain reading of clauses 1 and 2 of section 13(1)(d), it is apparent that proof of acceptance of illegal gratification will be necessary to prove the offences under clause 1 and 2 of 13(1)(d). In view of what is laid down by the Constitution bench, in a given case, demand and acceptance of illegal gratification by a public servant can be proved by circumstantial evidence in absence of direct oral or documentary evidence. While answering the referred question, the bench has observed that it is permissible to draw an inferential deduction of culpability and or guilt of the public servant for offences punishable under 7 and 13(1)(d) read with 13(2) of the Act. Conclusion is that in the absence of direct evidence, demand or acceptance can always be proved by other evidence such as circumstantial evidence. Then, your lordship may say, para 19 what they say. Now, considering the evidence on record according to the prosecution, direct evidence is in the form of evidence of PW5 S.K. Avasti. In this case, complainant has died, therefore he could not be examined. Raiding party consisted of PW5 Avasti, an officer in irrigation department, PW6 Mr. Yadav traffic inspector.
Code पढ़ुଛନ୍ତି?
Etam पढ़ुଛି para 19.
अच्छा. ଆଉ ଥରେ ପଢ଼ନ୍ତୁ.
Aye. Now coming to the evidence on record, according to prosecution, direct evidence is in the form of evidence of PW5 Mr. S.K. Avasti. In this case, complainant has died, therefore he could not be examined. Raiding party consisted of PW5 Mr. Avasti, officer in the irrigation department, PW6 Mr. Yadav traffic inspector, PW7 Mr. Niranjan Singh ACP.
Yeah.
Going by the complaint, which could not be proved through the complainant, it is the case of the prosecution that the first demand was made by appellant to complainant in the morning of 17 April 2000 when he met her at her residence. There was no charge framed on the basis of this demand. According to the prosecution's case, the second demand was made during the trap. There is absolutely no evidence about the first demand made in the house of the appellant, as no one except complainant was present there. According to the prosecution's case, PW5 was the witness to the second demand made by the appellant on 17th April 2000 at around 5:20 p.m. PW5 stated in his evidence that though complainant had informed the trap party that appellant will be visiting his shop at about 3:50 p.m., appellant did not turn up. Subsequently, a phone call was received by complainant informing that she would come by 5:30/6 p.m. Ultimately, according to the case of PW5, at 5:20 p.m., appellant with the co-accused came to complainant's shop. Version of PW5, which according to prosecution constitutes demand, reads thus. Mrs. Neeraj Datta asked the complainant to give papers regarding his electricity meter and rupees 10,000 to her as she was in a hurry. Complainant handed over the documents of his meter and treated GC notes of 10,000 to Mrs. Datta in her right hand after taking the same out of the left pocket of his shirt. Mrs. Datta handed over the said GC notes to her associate Yogesh Kumar to count and told complainant that his work would be done. The rest of the examination in chief deals with acceptance by appellant and recovery. Now the question is whether, on the basis of the evidence on record, prosecution has proved the demand of gratification by the accused. When we consider the issue of proof of demand within the meaning of section 7, it cannot be a simpliciter demand for money, but it has to be a demand of gratification other than legal remuneration. All that PW5 says is, when the appellant visited the shop of the complainant, she asked complainant to give papers regarding the electricity meter and rupees 10,000 to her by telling him that she was in a hurry. This is not a case where a specific demand of gratification for providing electricity meter was made by the appellant to complainant in the presence of the shadow witness. PW5 has not stated that there was any discussion in his presence between appellant and the complainant on the basis of which an inference could have been drawn that there was a demand made for gratification by the appellant. The witness had no knowledge about what transpired between complainant and appellant earlier. PW5 had admittedly no personal knowledge about the purpose for which the cash was allegedly handed over by the complainant to the appellant, just exactly as it is here. And therefore, their lordships allowed the appeal, my lords. Para 25, they say the appeal must succeed.
Yeah. IA number 8 रखिए. This is an application for stay of order of conviction.
The Constitution Bench, my lord. The Constitution Bench is in Neeraj Datta's case, my lord. Your Lordship have gone through the same. ନିରୋଧ ତ ମୁଁ ଡିସିସନ ଟା ଦେଇଛି ଆର କେସଟାରେ, ଏଇଥିରେ ଲିଷ୍ଟ ଟା ଦେଇଛି। ତା ଦେହରେ ଗୋଟିଏ ଜିନିଷ କହିଛନ୍ତି, in order to prove the fact in issue, namely the demand and acceptance of illegal gratification by the public servant, the following aspects have to be borne in mind. If there is an offer to pay the bribe giver without there being any demand from the public servant, and the latter simply accepts the offer and receives the illegal gratification, it is a case of acceptance as per section 7 of the act.
Acceptance ହେଇଯିବ ଯେ
Yes.
demand ଟା କଣ ଅଛି?
Demand ସେଇଟା ମୁଁ ଆସୁଛି. In such a case, there need not be a prior demand by the public servant. D1.
Statute ଟା ପୁରା କହୁଛି demand of illegal gratification.
Yes, I am coming. The observations which I am reading, my lord. On the other hand, 2. If the public servant makes a demand and the bribe giver accepts the demand and tenders the demanded gratification, which in turn is received by the public servant, it is a case of obtainment. And in the case of obtainment, the prior demand for illegal gratification emanates from the public servant. This is an offense under section 13(1)(d)(1) and 2 of the act. Of course, in E, it has been held, of course, a presumption of fact is subject to rebuttal by the accused. In the absence of rebuttal, presumption stands. So far as the section 7 is concerned, on the proof of fact in issue, section 20 mandates the court to raise a presumption that the illegal gratification was the purpose of a motive or reward as mentioned in the said section. The said presumption has to be raised by the court as a legal presumption or a presumption in law. Of course, the said presumption is also subject to rebuttal. Section 20 does not apply to section 13(1)(d). So, in this observation, the 20 is distinct from presumption of fact referred to in point E, जोटा मु पढ़ी.
All right, order reserved. Yes, next. And Mr. Devasis Pandal and counsel for the appellant, Mr. Sanjay Kumar Das, and standing counsel for the Vigilance Department. That IE number 1398 of 23. And counsel for the petitioner as well as the grand counsel for the state has filed some citations which are taken on record. Yes.
Item number 9. Item 9, Your Lordship, I pray for a short adjournment, my lord, my senior.
May I pray, my lord, after puja?
Your Lordship, the appellant will lose his job, my lord. Short adjournment kindly will later next week, my lords.
I have already filed my objection, my lord. On the last occasion, I have filed the decisions, my lord. It is in the flag. Decisions I have filed. It is at flag G. Flag G decisions are there.
You want adjournment?
Yes. Short adjournment, my lord. The appellant will lose his job.
Okay. 9th October 2023.
Obliged, Your Lordship.
Mention is made on behalf of Mr. Gautam Mishra, and senior advocate, to adjourn the matter, list this matter on 9th October 2023.
9th October, my lord, press admission, etc.
No, see, as you say, week or near you.
Yes, my lord.
Yes, next.
Lordship, kindly be listing supplementary list.
You'll see that on 9th, let it come. If it is done, reach then. Yes, next.
Obliged. Item 10.
On the informant, my lord.
It is on SAR 123(9).
The London Council for the State submitted that notice on the informant has been may served on 23/9/2023, and he has received the case diary. You have received. List this matter we commencing from 3rd October 2020. Yes.
Lords, can it be on 4th, my lords?
ଆସିବ 3 ତାରିଖ ଦିନ ଆସିବ 3 10/2023. Yes.
Item 13.
Yes, Mr. Rogan.
Please, Your Lordship. My lord, initially this case was registered office under section 3762N, 341, 294, 323, 506 of IPC, read with section under section 3 SCST Act, my lord, and subsequently turned into
Sufficient Allah? First time.
first time.
Oh, first time. Right. Extra copy to be served by tomorrow. Notice CD CA 9th 10 2023. Kali dei diyon to copy ta.
Yes, my lord.
Yes.
Oblige, Your Lordship.
Item 14.
Typographical error ହେଇଛି.
Your Lordship, in an order passed by this Honorable Court in IA number 2164 of 2023, dated 18/9/2023, the name of the appellant petitioner was
Appellant ନାଟା 1010 ର 1009 ରେ ରିଫ୍ଲେକ୍ଟ ହେଇଯାଇଛି।
କୋଉଟା କହିଲେ?
ଏଇଟା ଆଙ୍କ ନାଁ ହଉଛି ଯୁଗଳ କିଶୋର ପରିଡ଼ା। ସେଇଦିନ ବି 1010 ଥିଲା ସିଆରଏଲ।
so Drupad Sahasia.
ତା ନାଁଟା ଅର୍ଡର ନମ୍ବର 2 ରେ ରିଫ୍ଲେକ୍ଟ ହେଇଯାଇଛି ବାଇ ମିଷ୍ଟେକ୍।
Just a minute.
ଅର୍ଡର ନମ୍ବର 2। ଆପିଲେଣ୍ଟ ନାଁ ହଉଛି ଯୁଗଳ କିଶୋର ପରିଡ଼ା। ଖାଲି ସେ ନାଁଟା ଚେଞ୍ଜ ହବ।
IA number 2295 of 2023 is an application for correction of the typographical error in respect of the name of the appellant in order number 2 passed in IA number 2164 of 2023. The Land Council for the petitioner submitted that in place of the name of the petitioner Jugal Kishore Parida in the order number 2, his name has been inadvertently mentioned as Drupada Sahasia, and the same may be corrected. Land Standing Council for the Vigilance Department has no objection to the same. Accordingly, in the order number 2 passed in IA number 2164 of 2023, dated 18/9/2023, in the third subparagraph, where the name of the appellant petitioner has been mentioned as Drupada Sahasia, the same shall be read as inverted comma vitere Jugala Kishore Parida. The rest part of the order remains unaltered. IA is disposed of.
And the corrected free copy I have already sent the free copy.
A free copy of the order is handed over to the Land Council, Standing Council for the Vigilance Department. Urgency department. Yes.
Item number 15.
May I please, Your Lordship? Regarding the IL bail, the petitioner is in custody since 25/11.
You have received the case diary?
Yes, my lord.
Yes. On the last occasion, perhaps Your Lordship wanted to know information about the present status of the main kingpin. Lala Amritsar.
The matter is taken up so and so hard the Land Council for the
So
just a minute. Saroj Kumar Puri passing is taken on record on perusal of the order.
the main accused, he was granted interim bail by this Honorable Court on 2/5/2023. Thereafter, that bail has been extended by the Honorable Supreme Court, and he is out of jail right now. So,
London State Council submitted on that day that you are similarly situated like co-accused Lala Amrit Sagar Roy. So
he is on bail. He is out of jail.
Where is the document?
He was on interim bail by the order dated 2/5/23.
I just asked you to show the bail order to me.
Bail order. That was the interim bail order passed by this Honorable Court.
He was not released on regular bail.
Interim bail, but subsequently it has been extended.
Where is that order?
extended by Supreme Court, Honorable Supreme Court. That order they can apply to your lordship.
Why I can?
Because state that case number is not available. That is
No,
the
no.
whole problem.
Mr. If this particular order, it is on health ground, he has been granted interim bail.
Subsequently, it has been extended.
So where is that order? I just want to know. Now it's not difficult. You can put that name in the Supreme Court website and got the order when it was listed. What order has been? Everything is they uploaded there. Where are you finding is difficulty?
Well, may I pray that let your lordship direct the state to inform the court about his present status, whether he is in custody or not.
Supreme Court website रे आराम से पाई परिवे कौन कौन
ଆପଣ ମିଳୁନି, that is the whole problem. ସେଟା ଆମେ orderଟା ବାହାରିଲୁ, orderଟା ମିଳିଛି କିନ୍ତୁ ତାର ମିଳୁନି ତାକୁ. I need some time to find out.
It take time. But why should we?
Just.
And at parity, your lordship.
ସେଇଟା ପ୍ୟାରିଟି ରେ ମୁଁ ସିନା ଦେଖିଲେ ସେ ଅର୍ଡରଟା ପ୍ୟାରିଟି କଥା ବିଚାର କରିବି। ଏଇ ଯୋଉ ଲାଲା ଅମୃତ ସାଗର ରୟକୁ ସୁପ୍ରିମ କୋର୍ଟ ମେରିଟ ରେ ବେଲ ଦେଇ ସାରିଲାଣି। ଏଇ ଯୋଉ ଅର୍ଡରଟା ଦେଖଉଛନ୍ତି
he is referring to the two Lalit Soni and Saroj Prusti. They are totally different.
No. Lalit Prusti, your lordship.
In the first hour, your lordship had come.
Your lordship's order मिला।
ଆଜି first hour ରେ
Saroj Prusti मिला।
Item number 1, bail was granted to the that Saroj Kumar Prusti.
Different case, but in this case,
now
in the present case, my lord, in the present,
please bring that order. It is very easy. Why are you? Ask your associate to. It's very easy. How Supreme Court website को जाएंगे नहीं. Look, the Learned Counsel for the petitioner submits that the produce the interim bail order in respect of Lala Amrit Sagar Roy passed on 2/5/2023 in IN number 465 of 2023. However, he submits a bail application pending अछि na dispose of irani.
It is pending. But it has been extended by the Honorable.
All right. Submitted that the BLAPL number 3133 of 2023 is now sub judice before this court. However, against the grant of interim bail, the petitioner has approached the Honorable Supreme Court and the said order has been extended, and he seeks some time to produce the said order. Put up this matter. Kebe rakhibi kuhantu?
3 तारीख रे
List this matter on 3rd of October 2023.
Item 16.
16 will take some time, Millers.
This is that matter, let's say, where the order of cognizance.
Exactly, that
once
matter.
is
But
a
now
case.
we have found some decisions which support me, Millers.
Okay.
The 202 inquiry could not have been conducted without examining the complaint. There is an apex court judgment where the apex court categorically says so.
No, here I think complainant was examined under
Yes,
200.
yes.
No, complainant was examined under 200. Thereafter, he was not examined under 202.
Right. That is the case.
Now, your lordship may see that judgment, that Nagawa's case, Millers. There, the Supreme Court has specifically said, Millers, that it includes the complainant also. Paragraph 3. Your lordship may look at 76 3 SCC 736 at flag C. The third decision which I have given, flag C, my lords may see. This is 1976 3 SCC 736.
No, thereafter, Mr. Panda, thereafter decisions have come. I was referring
Yes,
to
yes,
that.
I'll come to that also. My lord,
Yes.
first look at this decision.
Yes.
First. From the placitum I am placing, the second page after the flag mark, my lords may see, CRPC 1898, section 202, scope, nature of inquiry under, magistrate only to be satisfied if a prima facie case exists, that is the head noting. The held the scope of the inquiry under 202 CRPC is extremely limited. Limited only to ascertainment of the truth or falsehood of the allegations made in the complaint on the materials placed by the complainant before the court for the limited purpose of finding out whether a prima facie case for issue of process has been made out and for deciding the question purely from the point of view of the complainant without at all adverting to any defense that the accused may have. So there, now my lords may look at the judgment at paragraph 3. At para 3, their lordship say, in Chandradev Singh versus Prakash Chandra Bose, this court has, after fully considering the matter, observed as follows. The courts have also pointed out in these cases that what the magistrate has to see is whether there is evidence in support of the allegations of the complainant and not, whether the evidence is sufficient to warrant a conviction. Learned judges in some of these cases have been at pains to observe that an inquiry under 202 is not to be likened to a trial, which can only take place after process is issued and there can be only one trial. No doubt, as stated in the subsection 1 of 202, the object of the inquiry is to ascertain the truth or falsehood of the complaint, but the magistrate making the inquiry has to do this only with reference to the intrinsic quality of statements made before him at the inquiry, which would naturally mean the complaint itself, statement on oath made by the complainant, and the statements made before him by persons examined at the instance of the complainant. So here their lordship say, referring to an earlier decision, my lords, that is 64-1 SCR page 690, that in the 202 inquiry, my lords, the complainant has to be examined and all witnesses.
Yeah, what do you say?
Now your lordship may look at the judgment in placitum A, my lords, Dilip Kumar versus Brajraj Srivastava. There is another judgment I have given in that compilation, placitum A, my lords. Paragraph 2 I am placing. This is a recent judgment. On 22nd August 2008, the learned magistrate passed an order directing holding of an inquiry under subsection 1 of 202 of the CRPC. The order indicates that the learned magistrate intended to himself hold an inquiry. Thereafter, the learned magistrate recorded the statement of only the first respondent oblique complainant and passed an order dated 18 September 2008 dismissing the complaint under section 203 CRPC. By the impugned order, the High Court has interfered with the said order on a limited ground. The High Court was of the view that there was no proper inquiry made by the London magistrate in terms of subsection 1 of 202 CRPC and therefore remitted the complaint to the learned magistrate. Learned senior counsel appearing for the appellant submitted that it was not mandatory for the magistrate to record statements of other witnesses. He submitted that after considering the statement of the first respondent complainant and the averments made in the complaint and other material on record, he rightly came to the conclusion that allegations were malified. He placed reliance on the decision of this court in case of Mohinder Singh versus Gunwant Singh and others. He relied upon what is held by this court in para 11 thereof. He also pressed into service another decision of this court in the case of Nagawa versus Viranna Sivalingappa Konjalgi. That judgment in flag C, my lords. Then at para 4, what their lordship say, my lord may say. From the middle of that para, I am reading. The law is well settled, which is found to have been reiterated in the decision in the case of Mahinder Singh Supra. After taking recourse to subsection 1 of section 202 of the CRPC, before dismissing a complaint by taking recourse to 203 CRPC, the learned magistrate has to consider the statements of the complainant and his witnesses. So the view taken by this court in the case of Nagawa is no different. So everywhere their lordship say, my lords, that in the 202 inquiry, the complainant has to be examined. And flag B, my lords, is the Mahinder Singh judgment. There at para 11.
Just a minute, Mr. Panda. Mr. Mahapatra, just think over it. No doubt this decision of division bench of this court says that if the complainant has already been examined under section 200 CRPC, it need not be examined under section 202 again. And if cognizance is taken, process is issued, then it cannot be said that it is illegal. Observation. Because Chandradev Singh says, Mr. Panda has pointed out, that complainant's examination at the stage of 202 is necessary. So that you verify whether that is this 5 judge bench decision on this particular point is unanimous, or there is a differing view on this particular point. We'll take up this matter next week. Okay. Mr. Devasis Panda, Land Counsel for the appellant, has filed a memo of citations, which is taken on record. During course of argument, Mr. Panda referred to the decision of the Honorable Supreme Court in case of Chandradev Singh versus Prakash Chandra Bose and others, reported in
64 Supreme Court, page 1470. I'm sorry, AR 63 Supreme
AR
Court.
63 Supreme Court 1430, wherein it is held that the object of inquiry under section 202 bracket 1 CRPC is to ascertain the truth or falsehood of the complaint. But the magistrate making inquiry has to do this only with reference to the intrinsic quality of the statements made before him at the inquiry, which would naturally mean the complaint itself. The statement on oath made by the complainant, the statements made before him by the persons examined at the instance of the complainant. Since Chandradev Singh is a 5 judge bench decision of the Honorable 5 judge, no, 4 1, 2, 3, 4. Aja, 4 judge bench decision. 4 judge केमती आला? देखी दे बेटा.
No, it's Justice Imam, Justice Subbarao, Justice Raghuvardal, and Justice Mudholkar. Yes,
4 judge bench decision. The learned counsel for the appellant respondent seeks some time to verify as to whether in the subsequent decision of the Honorable Supreme Court, wherein it is held that the complainant's examination at the stage of 202 CRPC is not necessary, even here if he has already been examined under section 200 CRPC, whether the decision of the Honorable Supreme Court in case of Chandradev Singh has been referred to or not. put up this matter in the week commencing from 3rd October 2023. সেটা সোমবারটা আবার ছুটি ହେଇଯାଉଛି ସେଥିପାଇଁ 3 ତାରିଖ ଆସିବ 4 ତାରିଖ ତ ଇଏ 5 4 5 ତ ହିୟରିଂ ଡେ ହେଇଯିବ ଆସୁ ସେଇଦିନ ଦେଖିବା 3 ଓକେ 10th of October 2023 ଆଉ ବାକି ଯୋଉ ଦିଟା ରହିଲା ଆସନ୍ତା ସପ୍ତାହରେ ନବା ୱିକଲି ସପ୍ଲିମେଣ୍ଟ କୁଆଡେ ଗଲେ ମିଷ୍ଟର ଆପଣ ତ ଆपिୟର କରୁନାହାନ୍ତି ନା ଯୋଉ ଚାର୍ଜ ବେଳେ ସେ ତ ଆସୁନାହାନ୍ତି କେତେ ଥର ହେଇଗଲାଣି କେବେ ରହିଛି ଆଜି ଆଉ ତ ଟାଇମ ନାହିଁ ଆଉ କେମିତି ଗୋଟା ଶୁଣାଣି ଗୋଟା ଟାଇମ ଟେକିଂ ମ୍ୟାଟର ଗୋଟା ଦିଟା କଣ
Time taking, your lordship had already heard the matter regarding stay application. Your lordship was pleased to pass an order and asked that if charge frame is in the lower court. Certified copy to produce.
That the case has been, I've told not sir, the case has been urgent to 5th October.
Just a minute, let me कोटा को जन CRL नंबर 625 to बाहर करो लास्ट ऑर्डर कौन है इतना okay the discharge petition was rejected and the case was posted to 15/12/2022 for framing of charge. So I just asked you to obtain and produce the certified copy whether the what is your instruction charge has been framed
This was posted on 21st September. Thereafter it was again posted to 5th October
for this purpose. Okay, the
certified copy
the learned counsel for the petitioner filed the certified copy of the order sheet which is taken on record from which it reveals that the case is posted to 5/10/2023 for consideration of charge. Place this matter on 3rd of October 2023.
May I pray for both the learned senior will be in contact for
সেটা আসি যাও সেই দিনও କହିଦେବେ 3/10/2023. Yes, Mr. Sarangi, what do you say? All right, let it be posted kept on that day on 3/10. So if it will not be taken up
on both the cases will come on 3rd October.
3rd October. So we'll pass you file if that day you on the first hour you make a mention and file a petition if it is not taken up. So later Cordian Khalil had Mr. Devasis Sarangi, Mr. Learned Counsel for the petitioner, Mr. Sangram Das, Learned Standing Counsel for the Vigilance Department on consensus of both the parties. List this matter on 3/10/2023. You take this order, urgent certified copy nekin de jodi 3 kohuchi emti na कौन है जी कौन है जी कितना
permission to proceed by the legal side. Confliction for the pensionary being held up. On the day of the
हाँ कौन एटा मु कहितली
recall petition ता आदि दबा
all right एटा को 10 item number 10 टा को the land counsel for the appellant submit that the matter may be taken up next week. List this matter on 3/10/2023.
Item.
सेया तो कहूथिले आपण कोन टा कहले अच्छा the land council for the appellant petitioner is permitted to remove the defect number 92 in court hala tang diyantu yes
Pardon, my lord.
Item 209.
urgent studies
Yesterday, my lord, I was mentioned, my lord, weekly list 234, my lord. For interim bill, the mother is serious condition.
ଆଣିଛେ ଇଏ ରେକର୍ଡ ଆଣିଛନ୍ତି କଣ ଆସିଲା 234 କୋଉ ଆଇ ଏଟା ଫାଇଲ କରିଛନ୍ତି
My lord, I
199423
my lord.
on what ground you are seeking for interim bail
My lord, the mother of the petitioner acquired a
gynecological problem
My lord.
so you have filed medical documents
My lord.
instruction was sought for and what instruction you have obtained not yet received or kon kara jibo not coming week re asibo ko seta
Let it come Friday, my lord.
friday au kon ani peribe friday ani peribe କେତେ ନମ୍ବର ସେଟା ହଁ ନେକ୍ସଟ ୱିକ୍ କରିଦେବେ କିଛି ଦରକାର ନାହିଁ ସେ ଅଟୋମେଟିକ ଆସିବ ନେକ୍ସଟ ୱିକ୍ ୟେସ୍
Item 219, your lordship. Lordship, I filed an IA for modification of the condition of bail,
119
your lordship.
just a minute what modification you want
Modification of condition of bail, your lordship. The deposit, she has been asked to deposit 21 lakhs, out of which she has already deposited 11 lakhs. In the meanwhile, she has been detected with fibroadenoma in the breast, your lordship.
okay Mr. Tripathi you obtain instruction on this particular which is that item
yes ma'am
219, your lordship.
219 ne instruction niyantu gote IA file करछनी modification
number IA number
IA number hochi 2067 of 23. Lordship, my only predicament is that she had been admitted rather, so for appendicitis to be operated for appendicitis.
it will come next week just
My lordship, only predicament is that she has to deposit the money within 10th of each month. And
10th
now,
we are taking up this matter on 3rd where you worried yes he will take instruction let you know next
I may be pardoned, my
Pardon,
lord.
my lord.
Item 16 in the supplementary list, my lord. There was an interim order. I believe that may be extended.
16 रे interim order थिला जब थिबो extend कर देबे हम
Your lordship, item 90 of the weekly list, your lordship.
कौन है की
Your lordship, CRLA 202 of 2022.
90 टा बाहर कले कौन है 90
Again.
को कौन तो कौन
IA number 1651 of 2023. Your lordship, we have filed a miscase for bail, your lordship. Now my predicament is my wife has been taken seriously. ताको severe anemia है ये चीज़ मैंने medical report भी आगे आनी पड़ना because she has nobody to support her.
so have you obtained instruction on this IA
Your lordship,
I for bail is there no there is a ground has been taken that in paragraph number 6
yes, your lordship.
wife of the petitioner is condition is deteriorating due to severe anemia and there is no male member to take care of her so that you obtain
Your
instruction
lordship, on earlier occasion गोटे police report call for hitla कहीं ना हमें आगुरु
the learned council for the state IN number लिखी देवे that is IN number 1651 of 2023 this is an application for interim bail na bail
नहीं again
bail in which one of the ground has been taken that the wife of the petitioner condition of the wife of the petitioner is deteriorating due to severe anemia. There is no male member for taking her care. The land council for the state seeks some time to obtain instruction on this.
again এটা ময়ূরভঞ্জ रहेगा
ময়ূরভঞ্জ ও সে 3 তারিখ আসো দেখিও
right long বাদাম পাহাড় ময়ূরভঞ্জ
অলরাইট
আমি পাড়া 224 মদার্স ইনভেস্টরে ইন্ট্রিম বিল পকেইଥିଲି লাস্ট উইক
ଆସିଲା କି instruction ଆସିଲା କି ସେ mention କରିଥିଲେ first hour ମୁଁ କହିଥିଲି file ଟାକୁ ଆଣିବା ପାଇଁ।
Yes, yes.
କୋଉ ସେଟା bill application number କେତେ? IA number 199 କୋଉଠି କେତେ number अच्छा paragraph number 4. Mother of the petitioner diagnosed with kidney so-and-so, ovarian so-and-so, immediate hospitalization operation. Okay, देखिए कौन आशा. With reference to the subject, I am to submit that requisition to so-and-so to verify genuineness of the medical prescription. To speed for the copy of the requisition is received the mail from so-on. It is assent in the verification of the medical that she has issued by so-and-so, and she has also reviewed during August when the available soon. She noted that. Okay. So the report is a genuine one, and is a man from Korea. आगुरु जाइथिला बेल के टीम तो लोकल सिक्योरिटी दियन तो से वेरीफाई करिवे केबे देबे लोकल सिक्योरिटी अपन तांको देले से आईआईसी थ्रू रे वेरीफाई करियो ना
ମୁଁ କହୁଥିଲି ଏବେ ପଢ଼ନ୍ତା ଆଇପ୍ରି ୱାନ୍ ଥିଙ୍ଗ ମିଲର ଟ୍ରାଏଲ କୋର୍ଟ କୁ ଦେଇଦେଲେ ଟ୍ରାଏଲ କୋର୍ଟ
ନା 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 ସି ଅସୁବିଧା ହଉ ସେଇଥିପାଇଁ ତ ମୁଁ ଏଠି କା ନହେଲେ ତ ସେଟା ଭାରି ଇଜି IN number 1991 of 2023. This is an application for bail on the ground of ailment of the mother of the petitioner. Medical documents have been annexed to the interim application. Land Council for the state was directed to obtain instruction on this interim application. Today, the Land Council for the state has produced the written instruction dated 25/9/2023 of IIC of Excise, EI and EB Unit 2, Cuttack, from which it appears that the medical prescription of the mother of the petitioner is a genuine one, and after 28/7/2023, her condition was again reviewed during August 2023, and there is kidney stone problem. The report is taken on record. The Land Council for the state has pointed out that the petitioner is a man from West Midnapur and the state of West Bengal. Let the Land Council for the
by tomorrow
appellant supply the names, address, and documents of two local security by
Mr.
tomorrow.
Tripathi,
By tomorrow to the Land State Council, which will be verified through so and so IAC of so on IAC. Through the IAC, है ना? All right. A matter to be listed 9th of October 2023. Item.
Malad item 197. Malad item 197.
instead of
I
9th,
filed an IA, Malad.
instead of 9th, I have some problem 10th.
10th good.
Malad item 197 on health ground I filed an IA for interim bail. Last occasion your lordship is directed to take it.
You should have mentioned in the first hour because the file is not with them. So mention in the next week, we will take up this matter.
That's it. Item 90, 3 copy. 90.
90. 90. 90. 90 free copy of.